I love.
Brian Walshe stands accused of murdering and dismembering his wife, 39-year-old mother of three, Anna. Her body has never been found. Welcome to live coverage and analysis of one of the most chilling trials Massachusetts has ever seen. With FBI Special Agent Jennifer Coffindaffer, host of Break the Case, Kevin Linehan, host of Yellow Cottage Tales, and former prosecutor Margaret McLean, host of It's a Crime with Margaret McLean. Good morning, everybody. Big day today. We have closing arguments in the Brian Walshe case. If you didn't catch up with the news yesterday, he refused to testify. So that was the big news. And big welcome to with the co-hosts here, or tri-hosts, Kevin Linehan right there from Yellow Cottage Tales, and Jen Coffindaffer from Break the Case with Jen Coffindaffer. Good morning, everybody. Happy Friday. It is Friday, right?
It is Friday. You know, when you retire, sort of retire, and you're not on a set schedule, it's always hard to keep track of the days, believe it or not.
It is. Oh my gosh, yes. And so, Kevin, you had something you wanted to start with. I'm going to start with you.
Yeah, thanks. I'm going to have to leave early. I have to go into Boston. I will be watching as much of it as I can. I may have to catch up on closing arguments. So this will be interesting today. These should be, for everybody watching, these should be really interesting closing arguments today. It's unfortunate that Brian didn't actually take the stand. That would have been very compelling. But we are going to get to hear what his defense lawyer is going to claim. I wanted to thank Margaret and Jennifer. It was a real pleasure being with them, as always. And also, I want to thank the audience, and that's really in chat. That's really what kind of makes it worthwhile for us. I think we all feel the same way. And so, I've been the last couple of days got to meet through our chat a regular from Jen's channel, Music by Brian. And he's been a great contributor in chat. And it turns out that he worked in a DNA lab when he was in college. So he's had some great insights or things that he can share with us. And I mentioned on the channel yesterday, and I said it's great to kind of add to the team as we grow, when we get new people with professional experience. And so then I got a really nice email yesterday from somebody new who apparently has been following us since the Karen Reed trial and is a huge fan. And her name is Lisa. She's from another state. I don't know where, but she has offered her help. She said she worked in a state forensic lab for 10 years. And she quit only when her kids started going to school. But it was a very nice. It's great to have that resource, and this is what we want to do: is add more people. Of course, we have great resources already with Jen with her career and Margaret with her career. But to be able to add more people that have those specializations, and I think that's what it's been rewarding here, and that's what it's all about. And hopefully, we'll continue to add more people. And she had also said that she valued what we value, which is not only, like you see, logic and evidence on my screen, but she values humility, openness, and I think those are all things that we all value too. So I just wanted to thank her and thank you guys, and hopefully anybody else like that wants to reach out to us. My email is leitskev, LEITSKEV @gmail.com, and I'm sure you can reach out to Jen and Margaret too, and we're glad to have you all. Thank you very much.
Yeah. Well said, Kevin. I agree. We've had great chat. I've really enjoyed looking at the chat stream because everybody comes up with such interesting perspectives, things that we've forgotten about. Like you guys are really following the case closely. I love it. And I'm interested in hearing the closing arguments today and seeing I'm curious as to how the defense is going to, talk about this is a textbook circumstantial evidence case. And I'm curious to see how the defense will argue against, saying, hey, there was no intent to, gosh, it's early. I need another cup of coffee. The Commonwealth didn't prove its case. And there's not enough evidence on intent. There's not enough evidence on how Anna was killed. So we'll see how, and it's not going to be Tipton. It's going to be Attorney Koss. So we'll see how she does. What are your thoughts, Jen?
Well, I want to mimic everything that Kevin said. I always say, I know we might not have the biggest channels, but we have the smartest channels. Are the people I think, that always reach out and I read, and I'm not just talking about the professionals. We have so many great professionals, but just everybody. And I always say the people in chat, you're who make up a jury.
Yeah.
Even though Kevin's been able to serve on a jury, and I'll never ever be able to serve on a jury because I will be removed quicker than they can say you're off because of my FBI background. That I don't know one agent that's ever gotten to serve on a jury.
I served on a jury.
I thought you had like a civil.
It was a civil, so you could possibly get on a civil case. I served as a former prosecutor, civil trial attorney, and professor at BC, and they still picked me for a civil contract case, and I teach contract law, or I taught it. So I got on. You just never know, and I was thrilled. Best experience ever.
I can see that. It's just in law enforcement, they don't like law enforcement officers up there. The defense attorneys don't, because they deal with law enforcement officers all the time. And they know essentially that we would never bring a case that we didn't 1,000% believe in. If you're a decent law enforcement officer. I always loved it when I was on the stand and a new defense attorney or a defense attorney that just wasn't thinking would say something like, well, what do you think? And I typically was always the synopsis person at the end of the trial for the prosecution that would really synopsize all the information that was presented. That was the kind of witness I was. And I loved it when they said that because I always said, looked the jury straight in the eye and said, I 100% think that they are guilty. Why in the world would I be here if I thought they were innocent? I would not be putting my name behind a case like that. And so it was always great. And then you just see the jurors kind of chuckle and go, okay. So just mistakes sometimes it's made.
Oh, yeah. That's why a defense attorney should never ask an open-ended question like that on cross-examination. It would open the door for you to say all sorts of things. And but they do.
Okay.
Okay. Were you headed out, Kevin?
Yeah, I'm shipping out to Boston. Oh, and I did neglect to say something that's very important too, is I forgot to thank our moderators, because we have the best moderators in the game who are not only doing a great job of maintaining chat and keeping it respectful, but who are very intelligently commenting on the case and following the case. So just to thank them too, the moderators for all of our channels. So thank you to them too. And I'll be following, I'll be listening. And if I can somehow get back and and we're still on the air, I will comment. I don't think I'll be home until after 1 though. So I may not make it this time. All right. Good night. Good night. Good morning, everybody. Thank you.
Bye, Kevin.
All right. Well, it's you and me, and I've got to check that court feed. So, hey, what do you think about? I've noticed you've been tweeting about a lot of other cases. What's your story? What are your headlines this morning, Jen?
Well, one thing, and I usually when I dig into a case, I try to follow it to the end. And one of the cases that's really just very bothersome is the Michigan coach. Michigan Wolverines, which are a very storied program. In 2023, they won the national championship. And after that, Jim Harbaugh, who had been their coach for years, he retired on top, which is a smart thing to do. And another coach named Sharon Moore, who was actually from the small Kansas town that my husband's from. So another reason that I particularly was invested in this. And anyway, he was not only fired, but it appears that he assaulted and had been stalking his assistant at Michigan, his little girlfriend on the side, young girl. He'd been married for about 10 years. I call that newly married in my book. Anybody who's been married about 30 years anyway, and had 3 kids, and he just sort of abandoned everything, including a $30 million salary to chase this girl. And he's on suicide watch. He's in jail right now. And it's just a hot mess. And it's just, disappointing anytime you see domestic violence, which is one of the things I always feature. And then especially a lot of people think it's just in the poor homes. It's not, it's everywhere.
Oh, yeah, no, it's everywhere. But it's amazing that he threw away such a prestigious career like that. Just think about it. And his family. I mean, okay, the money aside, I'm sure he had little kids at the time. If he was only married 10 years, they were probably all under 7 or something. I mean, my God, you think of that poor family, the poor wife. I mean, what is this guy thinking? I mean, he was obviously he was obsessive compulsive type of guy and had to have that girl.
Yeah, and you look at a program too that was, I mean, just talking about the football side of it, was number one in the nation, won the national championship, and the next year they were 8-5, unranked. I mean, they plummeted, and typically that's pretty unusual. Obviously, they graduated some seniors, but all the recruiters, the recruiting class they would have had would have been amazing because the national champion obviously is going to be able to recruit very well. And yet you've seen a program even at 9-3 ranked 18 really fell. So my point to this is when your coach is doing a lot of other extracurricular activities that have nothing to do with coaching, because good coaches are spending 80-hour weeks plus preparing their team, recruiting, that's who he should have been stalking, the best 5-star players in the country, not this little skirt.
I know. It's just nuts. And thank you very much. We appreciate that. The dream team. I like the fact that we're called the dream team.
Aww.
And, thanks to Kevin for bringing us all together.
Yes.
And yeah, and Kevin and I have become great friends. I don't think a day goes by that I don't talk to Kevin on the phone. So I've met his mom. She's wonderful. And he's just such an honest, talk about truth and honesty. Kevin is one of the most honest, truthful guys people I know. So thank you very much. And how is that feed going? Do they have the clock or the fan up yet in Court TV? Anybody know? Oh, there's Kevin. He obviously saw that. Yes.
Great.
I can double check. I was just checking. And of course, Mangione's in court today.
Still 2 weeks.
Yeah. I know.
Yeah, I just did a show with Sarah Zari, who's actually has her own show with News Nation now. Some people don't know that. She was a contributor like me. She was our legal contributor, and she's moved on to bigger and better things and anchoring a stream desk now that really takes the side a little bit of the defense. But in the last 2 shows she's had, she's invited me on the show. And for those of you who know my background and Sarah's, it's kind of funny to see this happening because Sarah and I were like this with Brian Koberger. I was on the side thinking he was very much guilty. She was on the side of very much defending him. Yeah. And really with every case, we've been like that and just at each other. And so now it's nice to really collaborate with somebody. She still has her own views on Mangione, but we're able to discuss that from, she took the legal standpoint that it was fruit of the poisonous tree, everything that fell from it because the search was illegal. I say, no way is it illegal. It was search incident to arrest. He could have had an IED in there and had something in his pocket and ignited that and blew them all up. I mean, this is a guy who made a ghost gun. This is a guy who shot somebody in the back, capable of egregious and atrocious acts. And then besides that, there would have had to have been an inventory search. There would have been a search warrant. So the doctrine of inevitable discovery tells us all of that would come in. I think it'll all come in. But it's great to have an intelligent conversation with somebody that's totally juxtaposed to your position on something.
Oh, absolutely. And I think she's good friends with Joel Waldman has worked a lot with him from Surviving the Survivor. I think he was also on her show. So that's, it sounds great. I've got to watch it. I haven't done it yet. I've been so busy with the Brian Walshe trial. So I'm just, the thing is up. So I'm going to share the screen here. Let's see.
Back, because I always do like to focus on the work at hand, even though we love to chat about fun stuff. Hope you all don't mind, and about other cases as well that are a spotlight. But, back to this case, what's really interesting to me, and this is critical, I think, is that you cannot, or you're not supposed to, and Margaret, you can expand on this, but you're not really allowed to talk about claims in your closing that haven't been admitted into evidence in the trial. So
correct. Yeah.
he's not allowed to get up there and say, look, there's all this evidence. She died in her sleep and everything. And believe me, the prosecution says they're not going to push back on the fact that even though they promised an opening statement that he would be testifying, he didn't testify. And it seems like they're giving really a lot of leeway to this defense counsel. But you're not allowed to do that. So I wanted to point that out if people didn't know. By him not testifying, they really have zero evidence for the jury to consider that she died in her sleep.
Oh, yeah. And here's another thing that I thought was interesting. So yesterday in the jury instruction, when they were having the conference on how the judge is going to instruct the jury, the prosecution team said they were not going to go there as far as saying, well, look, they promised an opening statement that you'd hear this, this, and this. And they're like, we're not even going to go there. Now, I think the reason they're not going to go there is because the prosecution knows they have a strong case, and the defense has that, Brian Walshe has that Fifth Amendment right, constitutional right not to take the stand. So they don't even want to touch on that, because if they mention something in the closing argument that touches on his constitutional right, it could possibly be burden shifting. So they are staying away from it. They could have hinted like you didn't hear any evidence on sudden, although they did hear a little bit of evidence on sudden death syndrome or whatever, some people suddenly dying in their sleep, with Tipton's cross-examination of the medical examiner. But other than that, they don't have very much to go on. And I think the Commonwealth is just going to show the jury how you can put together breadcrumb after breadcrumb after breadcrumb. And you've got a whole picture of a murder here, first-degree murder. So
right, the inference that can be drawn both from what was done in advance of the crime and what was done after with those Google searches. And then in addition to that knife with the blood on it, I really think they need to particularly talk about that. That's not a dismemberment tool. That would more likely be a murder tool. And they've got that introduced, and they could try to extrapolate and draw that inference. I've drawn that inference, and I know a lot of people have. You know what, Margaret? I have got to rush off. I'm on court TV this morning.
Okay.
10 covering Brian Walshe trial, and but I'll be right back after that.
Oh, no problem. I can handle it by myself. I've got I'm looking at the feed here. I'll put that up right now. I'll add that to the stage. But Jen, great discussion as always, and we'll see you soon. So
thank you.
And here's the feed here. Well, anyway, it's me and you guys. So if you guys have any questions about it, what we expect to hear, I am interested to see how long, I'm wondering how long the jury is actually going to take to convict. We were predicting that last night. I would say maybe they're going to go through the evidence and we could possibly have a verdict later this afternoon. What do you guys in chat think about that? Prediction: 1 hour, 3 hours, a day? Will it carry over till the weekend? So I'm not sure, but an hour. So Jeff says an hour. I also think some of my observations about this trial, first of all, as far as the knife goes, you look at the timing of the Google searches, and when he, Googled about the knife and the dishwasher, you could make the argument that he Googled prior to Googling about, how to dismember. So I think it's possible he could have used the knife. There's so much blood on it. And the knife was, don't forget, up in the cupboard next to the hydrogen peroxide. So I'm thinking, hey, maybe that's how he tried to clean the knife and then put it in the dishwasher, and then Googled, does a dishwasher, putting a knife or whatever the Google search was, putting something through the dishwasher, does it remove blood? And it didn't completely remove all the blood. And then another thing I think is significant is the broken necklace. To me, that sounds like a struggle. And people have also asked, why, going back to the knife, why didn't he throw the knife away like he threw the hacksaw away? They found that in the Peabody dumpster, and the hacksaw and some of the other things. I'm thinking maybe he forgot the knife was up there. Don't forget he's nervous and he's panicking. And if the knife was used for dismemberment, why did he have to go get other tools at the store? Yeah, I think he wouldn't have needed to. I believe he stabbed her. Yeah, I completely agree with that. And I think the jury is allowed to make a reasonable inference there. And again, they can't make a leap of faith, okay? But they can make reasonable inferences and put all the evidence together. And they will talk about that. But I guess the concern would be, is there going to be one or two holdouts who follow that letter of the law and say, the defense hasn't proven this case beyond a reasonable doubt as to whether Brian actually killed Anna. So I don't know. But when I went into court, they all looked very grim. So I think my guess is that Brian looked at those jurors and they had that look of conviction in their eyes, and he's just threw up the white flag and said, forget about it. I'm done. I surrender. And I think that happened very late in the game. Let's see what else you guys say. Here's a good one. I'm not sure I agree his attorneys are great. His best appellate issue is probably is ineffective counsel. And Brian, I do agree with that. Tipton is supposed to be, he's got a great reputation here in Massachusetts. Like, he's one of the best public defenders, and we do have great public defenders. We really do, especially if they're on the murder list. But what I have a problem with as a lawyer is if I'm defending the case and my client, Brian Walshe, tells me, I am taking the stand, I'm telling my story, and let's say he's really adamant, and he's been adamant since day one, since the day you got the case. Well, he still has the right to change his mind. And we know that in 95% of these criminal cases, the defendants don't take the stand. And of course, Brian knows that, right? He knows that. So I think Tipton made a mistake by promising too much in that opening statement. He could have simply talked about, the Commonwealth's burden to prove its case beyond a reasonable doubt. And there isn't enough evidence. You will see there won't be enough evidence to prove that he actually killed Anna. And he could have gone on about, you will hear evidence about sudden death, how it happens in young people and old people and people who are very much in shape, athletes, and then stop. All right. And if Brian decided to testify yesterday, then he could have gone and explained in his closing argument that, whatever he had said in his opening statement. So save it for closing argument, because I think Brian will get an appellate lawyer and appeal on that issue that, here's jurors, right? They're thinking, well, wait a minute, this lawyer's not telling us the truth. How can we trust anything Tipton says, right? The most important thing is trust. So I think there might be an appellate issue there. Whether Brian will win, I don't know, but I think it's, I would not have made those. I think it was very bold of him to do that, Here's another. I think they started, this is Kevin. I think they started arguing in the kitchen when cleaning up after the dinner party. She said something, he snapped, grabbed the knife, and stabbed her with the knife, hence the blood and the wooden floorboard. I think, you can argue that. And I think maybe there was a struggle. Maybe there was a struggle for the knife, or there was something went on, and that's when the necklace got broken, and I think they need to make, because, it's a broken necklace. I mean, was she wearing it at the time of the struggle, or did he rip it off her? I don't know. But that would be my guess there. Here's another one. First degree murder, no parole. You won't see the light of day ever again. So I think the majority of jurors will want him to see him convicted. But there's that one, you never know about that one who is, back in the day, well, actually for both civil cases and a prosecutor. So as a prosecutor, there were certain jurors that we didn't want on, and, based on their careers. So I never wanted an engineer, especially from MIT, on my jury, because I always felt that an engineer would be too analytical and they would find reasonable doubt. So there's a lot that goes into jury selection. So if we have an engineer or, a mathematician or an accountant, that's another one, an accountant. I didn't want an accountant at my jury. So they're so black and white and so analytical that they might find reasonable doubt in, like Jem. I think Jem Mutlu is that type of person too. Like he just couldn't, he's letter of the law. And if he wasn't a great witness as far as remembering what Anna said. So like a Jem Mutlu type of person might overanalyze the case as well. So, and what else do we have in chat? Let's see. Hopefully the jury can see all the evidence that's overwhelming. Yeah, they need to piece together the evidence. It doesn't take a rocket scientist to figure this out. I agree, Jeff. It doesn't take a rocket scientist, but a scientist can be very, analytical. So I just, that's all. But I agree, Jeff. I think that overall, what usually happens, I was a juror, let's say you have two holdouts, believing that the Commonwealth didn't make its case here based on the first degree murder, the elements. That's when the other people will kind of put a little pressure on, like, come on, we did it. Look, and they'll point to pieces of evidence like the broken necklace, like the knife, like the order of the Google searches. And don't forget those 3 Google searches that mentioned the word murder too. And I think we're about to start. No, I don't know. They just moved it a little bit. So here's another one. You are right. Without a body, there could always be that 1 or 2. That's right. There's no body in this case. So you just never know. Brian Walshe, there's so many other things he could have done. I mean, he must just be sitting there as he, listened to the testimony all week, that how dumb was I to Google search this? How dumb was I to, be caught on surveillance dumping trash bags with the hacksaw and all that stuff. I mean, we live near the ocean. I mean, he could have easily thrown her body off the bridge that goes right into the Atlantic Ocean, which is about a mile from my house. There's a big current there. At least take the body out, and then, most likely she would wash back up. But, I don't know. It's he's probably thinking I was really stupid. So poor Anna. I thought it was interesting that here's the judge. All right, let me see. Let me make sure I have the volume on.
For the Commonwealth versus Brian Walshe, criminal indictment 2023-0091. Matter continues on jury trial. Counsel's present in court. Counsel, starting with the Commonwealth, kindly identify yourselves once again to the court and the record.
Good morning, Your Honor. Greg Connor for the Commonwealth.
Good morning, counsel.
Good morning, Your Honor. Ann Yaz for the Commonwealth.
Good morning.
Good morning, Your Honor. Tracy Cusick for the Commonwealth.
Good morning.
Good morning, Your Honor. Good morning, everyone. Kelly Porter on behalf of Mr. Walshe.
Good morning.
Good morning, Your Honor. Larry Tipton for Mr. Walshe.
Good morning. We'll wait for Mr. Walshe, but while we're waiting, I'm just going to pass you out a couple of versions of something I want you to look at. I have a preference. I don't know how many copies that is, but I think it might be enough. If we need more, I have more. I just put that to the side, council, until we get there.
Thank you.
All right. Good morning, Mr. Walsh. I said good morning to everybody else, so good morning to you too. So since the version that I sent you at 1:55 PM, I've made the following edits. Either based on prompting by you or by my own accord. So on page 9, the use of a dangerous weapon is out. On page 17, the stipulation, separate instruction, I incorporated that into the evidence instruction. On page, it was on page 19. So what I did is I just added into page 19 some text. It's the second sentence. The evidence consists of the testimony of the witnesses, as you recall it. And then I just added in there the things that were marked as exhibits and the stipulation/agreements of the parties, rather than have it as a separate to-do. Just making it a little bit more streamlined. I edited out the last sentence of graphic photos. Instruction on page, I think it goes to the top of full page 18 as irrelevant to this case. And I also have removed the separate section later on page 18 about opinion testimony as repetitive of the expert testimony section above. On page, old page. Now I can't find it right away. You may know where it is when you read through it. It says you'll have all the evidence with you. And I removed the non-relevant weapon and put in including the tools. But as I was thinking about that last night, mental note was, what does the Commonwealth, or how does the Commonwealth intend to safely put those tools? So what I've done in other places, or what I've seen done in other places, and it most often comes up in the context of a knife going back. I've seen other DA's offices basically take the knife and it's like they put it on a hard board and then they strap it down. So the jury can see the item but can't hurt themselves unwittingly with the item. It seems that the same could be done of the tools in this case, if you have the capability to do that. I think I've seen that done in Middlesex, Plymouth. That's how they sort of handle the issue. How are you planning on handling it?
We're working on it this morning, though.
Okay. So what I have in my mind, just so that, and I think law enforcement in the past has done it for the DA's office. So they may have the strapping mechanisms, but as long as I'm assured that they can go in safely to the jury deliberation room, either with a sheath cover on it, or preferably strapped down to a hard board, it seems to me that that would be a good approach. Anybody object to that?
No, Your Honor. We'll work with defense counsel, but we're trying to get some supplies to do that this morning.
All right.
We don't have any.
So I passed out to you two versions. I went back to look at different instructions I have. I looked at a few different things, and this relates to the direct and indirect evidence instruction. And the version 1 is what I will call I put this in air quotes, I'll call it the Superior Court version of or what I most often see in the Superior Court, which is different than the District Court version, which is a little clunkier, I think. But anyway, you always like what you like, right? That is probably the more traditional, old-fashioned perhaps. As I read through it last night, I think it reads better than the version that I put into the first draft, but I don't have strong feelings about it. So if we have agreement between the parties as to which one you like better, I'm happy to read that. I think both of them are accurate representations of the law. I have a preference for version 1. Take a look at that and let me know when you've finished looking at them and have an opinion.
Your Honor, the Commonwealth doesn't take a position. Neither one seems
Fine.
comfortable.
Normally, honestly, I don't spend a lot of time on this in most cases but this case is one that I spent a little more time on it. Yes, Attorney Porges.
Your Honor, we're requesting version 2. So if no one else has a position, I'd ask the court to read that one.
All right, which is my version 1, I guess, right? It's the version that was in the instructions yesterday.
I believe so.
All right. Both are correct recitations of the law, so if you wish to draw from any of them, they're all good. And I'm not sure that they make a huge difference. All right. Any other edits to the draft instructions beyond those that I've just incorporated?
Your Honor, on page 12 of the 155 instruction on reaching a verdict, I believe there's some references for each charge, and I would suggest that that might have been a carryover, the plural version.
The 4-person,
I have page 12, reaching a verdict, the 3rd paragraph for each charge,
for the charge, yep.
and then has proved every element of the charge beyond a reasonable doubt, then you should find that Mr. Walsh is guilty of the charge or just is guilty.
Okay,
In the next paragraph,
and same thing, particular?
yes, Your Honor, particular, and then the on that charge.
I just ended it, not guilty.
Your Honor, on page 13, role of the jury, 2nd paragraph. Do not be influenced by the nature of the,
Charge?
yes, Your Honor.
I think I already made that change. I just didn't tell you I did.
Your Honor, on page 31, alternate jurors, I believe there's a reference to 3, and I believe it's 4.
It is. I made that change later in the day too, and I didn't tell you about that either.
That's all the Commonwealth has identified, Your Honor. Thank you.
Anything additional from the defense?
No, Your Honor, content, except for the previous exceptions made.
I'll Although now I think most of the previous exceptions you made have been removed,
Just being cautious.
but I get the point. All right, let me step off the bench quickly and make these changes. And the reason for that is I want you to each have a to have a copy so that you can follow along while I'm doing it. It shouldn't take me very long.
All right.
Good morning again for everybody joining us. They were just talking about the final edits to the jury instructions. So, and how they're going to put that knife into evidence. So basically, when the jury receives the knife, it's into evidence. We should cover it with a sheath, just in case there's a big argument in the jury room and somebody stabs somebody else. So they think about safety. And as far as I don't see anything too major here. I think, again, they are taught, it doesn't sound like the lesser includeds either will be part of the jury instruction, because I don't see so far where the Commonwealth or the defense has asked for them. So that means the jury will just be deliberating on first-degree murder. So they will be hearing one of the jury instructions that I think is interesting to point out is prior bad acts. So what the judge will instruct the jury is, because the defendant, Brian Walshe, had some prior bad acts, and though there's 4 of them, and let's see if I can remember. One is the federal fraud case, lying to the parole officer, and dismembering Anna, like about her, her body. And then the 4th one is, I can't remember. But anyway, so it's very important that the judge, they can consider those 4 prior bad acts as, evidence towards motive, but that not going towards the bad character of the defendant. For example, well, because he committed fraud and he's been convicted and was awaiting sentencing, that means he must have murdered his wife, Anna. So they can't make that jump. Or just because he dismembered Anna, well, then he must be a murderer. He must have murdered her. So you can't do that. So the judge is very good at explaining to the jury, you can't use evidence of prior bad acts to decide that he is a bad character and the propensity to commit murder. So you can use it towards, it's a fine line, but towards motive, towards consciousness of guilt. So another thing they're going to do is the instruction on prior bad acts will be close to the instruction on consciousness of guilt. So the jury's like, all right, we can consider those acts, but only for this limited purpose. And of course, they're going to be thinking in their minds, oh, he must have killed her. But the judge has to be careful of that. Well, okay. So, Jack, I haven't seen the jury instructions, but I would think the jury would be interested on 1st and 2nd degree murder. So Jack Liu is a retired Massachusetts judge, very smart. I've had him on my show. And Jack, since you're listening, I'd like to ask you, in this particular case, so far it's 1st degree murder, right? That's, as far as I know, that's what they will be considering. But the Massachusetts jury cannot, on their own, by themselves, decide, well, this must be 2nd degree or manslaughter. It has to be requested by the defense or the prosecution, first of all, and then the judge has to make the final determination whether those lesser includeds can come in. And as far as I've seen, I don't see where either the defense or the prosecution has requested the instructions on 2nd degree murder or manslaughter to come in here. So I think in this case, the jury is only considering 1st degree murder. Now, I'd love to hear what you have to say on this one. So I'll be waiting for that one. And good morning, everybody. I agree with Jack. Yeah, I agree with Jack too. But again, Massachusetts is interesting in this particular case. The jury can't decide that on their own, so they can't. If they just have first degree murder, right? They can't say, well, this sounds like second degree murder. They can't do that by themselves. So, here's Jack. I believe the judge will likely instruct the jury from the language of the statute. The statute says something like the jury will decide the degree of murder. Well, we'll have to listen to the jury instructions. I thought that they could only instruct on first degree. So we'll see. But thank you, Jack. Any other thoughts, Jack, on what how you think this will go? I'd love to hear what you have to say. And it's very different from the Karen Reed trial. Jack was on my show for the Karen Reed trial, and we were also together on Canton Confidential, now called Commonwealth Confidential. And we shared the same views about Karen Reed, that there was enough evidence to convict her. Good. Jack says, I will look up the statute. Thank you, Jack. I appreciate it. That's great. I love having judges like Jack and Carol on the show. It makes us, it's very helpful, And then let's see what Maureen says. They can't consider any other prior bad deeds, not pleas. Yeah. So they can consider those prior bad acts or plea, that he pled guilty in the federal fraud case. Okay. Federal fraud case, but not to go to his character. Now, they also, and I think Maureen pointed out that I forgot to mention, is the jury can't consider, they won't know that he pled guilty on misleading police and improper disposal of a body, right? So they're not going to hear that, which is very interesting. Now, I think if Brian had testified, then they would have heard that. So the judge was kind of waiting on that. And again, the judge was very surprised yesterday that Brian decided at the last minute not to testify. I mean, from the bench, you could tell. She's like, I did all this work for nothing. And she's kind of funny. She's a little dry sense of humor. And, and she's quick, very smart as a whip. Here's Jack again. Okay. Yes, different from the Reed case. No intimidation or pressuring of witnesses and jurors. Yeah, it is very different. I mean, I went into court, and the day, when I went, there was just the press there. And sadly, there was no one there supporting Anna, like none of her relatives. The only supporter there was Brian's mother. Now that could have changed. I know a lot of people went yesterday anticipating that Brian would testify. In fact, I was headed to the court and I turned back around when he decided not to testify. I was just kind of disappointed in that. I was looking forward to the fireworks. I like the way Jack Lou thinks. Yep. I do too, Jack. I would have loved to have practiced in front of you, Jack. That would have been awesome. Yeah, her sister from Ontario did not attend. Yeah, I know it. I mean, that's sad. And, the sister from Ontario didn't take the kids either. So I think that's sad, just from a mother's perspective. I feel for those boys. My God. I mean, yeah. Where's Anna's family? Well, Anna's mother's in Serbia, and I get it. She's older. I totally get it. She couldn't travel. And Anna has a lot of friends in the area. Maybe they were there yesterday. Maybe they were under sequestration order because they could have been called to testify. So remember, sequestration orders mean that you can't watch the case as it goes on unless you're family. So maybe they couldn't watch the trial. I mean, Jem Lutlu, her friend, could not sit there and watch the trial for sure. So I'm sure he was under an order. Now, I wouldn't be surprised if some of the supporters for Anna, and I hope they're there today, because jurors notice that. I mean, I don't know if it'll make a difference in this case because, I think jurors have a picture of who Anna was. And especially from the last few witnesses. Her friend, I thought, who was wonderful, the last witness to testify, Alyssa Kirby, was just so distraught on the stand. And I think she brought Anna to life, as well as Jem brought her to life, as you know. Oh, here's Kevin. Sister lives in California. Maybe it's too painful for the sister. It's painful, but it's a support thing. I mean, I get it. I get what you're saying, Maureen, but I mean, yeah, but you know, I feel like I'm a big advocate for victims, and I feel like, you know, yeah, I would be there if something happened to my brother. It's as hard as it would be. Canada, Ontario, I know people are saying different places, but yeah, Ontario is not from Massachusetts. I know it's Canada, but it's far, but still, that's not crazy to be able to, you know, take a flight these days to support your sister. I'm just saying. Jack, oops. Good morning, Margaret and Maui. Thank you, Jack. Good morning again to you too. So what did Jack say? It would not let me copy and paste the statute. Okay. Well, what did it say is, you know, as far as allowing the jurors to consider the lesser includeds of first-degree murder, Jack, if they were not requested by the defense or prosecution? I don't believe they can consider those lesser charges if it wasn't requested specifically. And then the judge has to decide. So, I mean, that's the way I read the statute. Jack, did you too? The kid, I can tell you right now, the kids are not with the sister. I know who the kids are with, but I can't say it online. And I'm not too happy about who they're with. And here's Jack again. I love the fact that you guys are helping me out. I'm solo today. Woo! The quote above is from the statute. Looks to me like the judge must tell the jury you decide first or second. But I believe it's up to the judge. Oh, there's a super flu going around. Oh, gosh. I hope I don't get that. I hope nobody gets that. That's awful. Where's the quote above, Jack? I missed it. That's what I thought. Maui, I thought the same thing. The way I read it, that the attorneys had to request it. And I don't see where they requested it at all, because that would have come up yesterday or indefinitely this morning in the conference on the instructions, because that's a big instruction, and there would have been quite a bit of discussion on that. And I didn't see it, and I did listen very closely to the conference yesterday. So what is this? What are some of the toughest cases you've done, Margaret? Oh, geez. Some of the toughest cases I've done. Well, okay. The toughest cases were sexual assault cases against, very young children. So those were really tough to do, to prosecute. And then as a prosecutor in Lawrence, I'll tell you, it was kind of crazy, but sometimes you had to screen cases in and screen cases out ahead of time. So you'd be behind a two-way mirror as, someone is questioning the juvenile about this horrible rape, and you have to decide, is this a case we bring forward? So I thought those were some of the toughest emotional cases that I've tried. But I also, having that experience, I also know that it's really sad, but sometimes there's a situation, which I've seen, where you might have domestic issues. Like, for example, you might have a vindictive male or female who just hates the other partner so much that they get the kid to say, oh, he touched me inappropriately. I've seen that, and that's awful too. I feel like those people should also be brought up on charges, and they never are. So, but those I think that would be some of the toughest case. Here's Jack Lou. That is a mandate from the murder statute. Doesn't matter what the lawyers request. All this is my opinion. I love your opinion, Jack. I love it. So yeah, can't stand crimes against. Hey, Jack, what are some of the heart-wrenching cases that you had as a judge? Just curious. I'm sure probably along the same lines, I would imagine. Yeah, false allegations. Where is it? Sometimes the chat goes so fast. False allegations need to be prosecuted, and they really aren't. I haven't seen it, and I've seen some doozy false allegations, just some awful cases, and it can be in, doesn't matter. I've seen them in wealthy communities. I've seen them in low-income communities. So this stuff happens, and it's really horrible. People get so angry and vindictive against the other partner, and it can get really ugly. So, and yes, I agree. People do abuse the courts. Absolutely. Well, I hope the closing arguments come soon. I've got to figure out, I've got to drop my kids off at Logan, but I think I'm going to throw them into an Uber or a Lyft and say, off you go. They're going away for the weekend for their dad's birthday. Okay.
You are unmuted.
I guess I'll take myself off. There he is. Convict him. Sorry, I should be neutral.
Everyone all set? Good.
All rise, jurors entering. Hear ye, hear ye, hear ye. All persons having anything to do with the Honorable Justice Diane Frenier, Justice of the Norfolk Superior Court, draw near, give your attendance, and you shall be heard. Court to the Commonwealth of Massachusetts in this honorable court. Please be seated. Please turn up your cell phones.
Jurors, and welcome back to Northern House. Jurors, will start today as we have every day together with the 4 questions. Jurors, were you able to comply with my order that you not be on any social media or any news media?
Yes.
And were you able to comply with my order that you not do any research about this case?
Yes.
Are you able to comply with my order that you not speak to anyone about this case?
Yes.
And you all still have open minds?
Yes.
Those 4 answers for the record all answered affirmatively by all 16 jurors in the box. We're ready to begin today's work. So as I promised yesterday, jurors, there's 2 chapters that will come interspersed now as we start today. And those chapters are that I will give you the instructions that are specific to the charge of murder here in this case. Then the parties will do their closing arguments. And then depending on how you're doing, given the time that's passed since then, we may have a short break, bathroom break. Then I'll come back and give you the more generalized instructions on the law. Deliberately break it into 2 chunks. It's more consumable for you that way. The jurors, I want to thank you for your service on this jury. To a person, when I've looked over, you caught me many times looking over at you. You've been paying attention, and that's exactly what I anticipated, but it's refreshing and rewarding for me to see it. So I know that you have paid attention to the evidence in this case, and I appreciate your attention. Your jury service in this case is a very important part of our democratic self-government. You are responsible to uphold the law and our principles of justice. That's what you promised to do at the start of this trial when you took an oath as a juror. You've all devoted a substantial period of time on this case, time away from your personal lives, your work, studies, your families, to sit as jurors in this case and to decide the very important matter, an issue now between the Commonwealth and the defendant, Brian Walshe. You've done so in accordance with the finest traditions and the highest aspirations of our system of justice. Again, I thank you for your service and your sacrifice. You must now consider all of the evidence, decide who and what to believe, and decide whether the prosecution has proved beyond a reasonable doubt that Mr. Walshe is guilty of the crime of murder. The final part of this trial, as I said, will take place in those 3 steps. First, I'll give you on the law that is specific to the charge in this case. Then the attorneys will make their closing arguments, in which they will highlight the evidence that they think is important and will argue in favor of the conclusions that they ask you to make. Defense attorney, Attorney Tipton, will argue first, and the prosecutor, Assistant District Attorney Yaz, will argue last. After the closing arguments, again, I'll give you those generalized instructions that will help guide your evaluation of the evidence and your decision-making and your deliberations as jurors. And then you will work together to reach a unanimous verdict. Please pay careful attention to all of my instructions. All of my instructions are important and you must follow them, whether you agree with them or you do not. To make sure that I give you the instructions accurately, you can see that I'm generally reading them to you. You will also get written copies of the jury charge, the jury instructions, in the jury room when you deliberate the case. I do my best to make sure that the instructions that I'm giving you while I'm speaking match these written instructions. If there is any difference between what I say aloud and the written instructions, please follow what I say aloud. So let me start with the prosecution's burden of proof, and I'll start with the presumption of innocence. There is a fundamental rule that applies in all criminal cases, including this case. Every person who is accused of a crime is presumed to be innocent of that crime. Mr. Walshe is presumed to be innocent of the charge in this case. That means that you must consider Mr. Walshe to be innocent unless the prosecution has proved beyond a reasonable doubt through evidence presented at the trial that Mr. Walshe committed the crime charged. And I will explain what I mean by reasonable doubt in a minute. Mr. Walshe does not have to do anything to convince you he is innocent. He does not have to explain anything to the jury. Mr. Walshe does not have to testify, call or question witnesses, or provide any evidence at all, because you must presume he is innocent. Instead, it is up to the Commonwealth to prove the charge against Mr. Walshe beyond a reasonable doubt. This burden of proof never shifts to the defendant. After you have considered all of the evidence carefully and fairly, if you have a reasonable doubt about Mr. Walsh's guilt on the charge of murder, then your verdict must be not guilty. You may find Mr. Walshe guilty of the charge of murder only if all 12 deliberating jurors agree that the Commonwealth has proved the charge beyond a reasonable doubt. So the burden is on the Commonwealth to prove beyond a reasonable doubt that Mr. Walshe is guilty of the charge made against him. What is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt, or everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proof beyond a reasonable doubt if, after you have compared and considered all of the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in this case. I've told you that every person is presumed to be innocent until he or she is proved guilty, and that the burden is on the prosecutor. If you evaluate all of the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. That's what I mean by proof beyond a reasonable doubt. There's one indictment or charge in this case. You must decide whether Mr. Walshe is guilty of that charge. For the charge of murder, there are certain things, we call them elements, that the Commonwealth must prove beyond a reasonable doubt to show Mr. Walshe is guilty. I will explain these legal rules to you now. There are two different degrees of murder. Murder in the first degree and murder in the second degree. If you find the defendant guilty of murder, you shall decide the degree of murder. Commonwealth alleges that the defendant committed murder in the first degree on a theory of deliberate premeditation. To find the defendant guilty on this theory of murder, you must be unanimous. That is, all of the deliberating jurors must agree that the Commonwealth has met its burden of proving every element of this theory beyond a reasonable doubt. If you are unable to agree unanimously that the Commonwealth has met its burden to prove beyond a reasonable doubt this theory of first-degree murder, you shall consider whether the Commonwealth has proved the defendant guilty beyond a reasonable doubt of murder in the second degree. I'll begin by instructing you now on the elements and the additional requirements for the proof of murder in the first degree with deliberate premeditation, and then I will next instruct you on murder in the second degree. Murder with deliberate premeditation. To prove the defendant guilty of murder in the first degree with deliberate premeditation, the Commonwealth must prove beyond a reasonable doubt the following three elements. First, that the defendant caused the death of Anna Walshe. Second, that the defendant intended to kill Anna Walshe. That is, the defendant consciously and purposefully caused Anna Walsh's death. And third, the defendant committed the killing with deliberate premeditation. That is, he decided to kill after a period of reflection. I will now discuss each of those requirements in more detail. The first element is that the defendant caused the death of Anna Walshe. A defendant's act is the cause of death where the act in a natural and continuous sequence results in death, and without which death would not have occurred. The second element that the defendant intended to kill Anna Walshe. That is, the defendant consciously and purposefully intended to cause Anna Walsh's death. The third element is that the defendant committed the killing with deliberate premeditation. That is, he decided to kill after a period of reflection. Deliberate premeditation does not require any particular length of time of reflection. A decision to kill may be formed over a period of days, hours, or even a few seconds. The key is the sequence of the thought process. First, the consideration whether to kill. Second, the decision to kill. And third, the killing arising from that decision. There is no deliberate premeditation where the action is taken so quickly that a defendant takes no time to reflect on the action and then decides to do it. Murder in the second degree. In order to prove murder in the second degree, the Commonwealth must prove the following elements. First, that the defendant caused the death of Anna Walshe. Second, that the defendant A, intended to kill Anna Walshe, or B, intended to cause grievous bodily harm to Anna Walshe, or C, intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. I will now discuss each of these requirements in more detail. The first element is that the defendant caused the death of Anna Walshe. The defendant's act is the cause of death. The act, in a natural and continuous sequence, results in death, and without which death would not have occurred. As you can see, the second element has three sub-elements, which I'll call prongs. And the Commonwealth satisfies its burden of proof if it proves any one of the three prongs beyond a reasonable doubt. The first prong, the defendant intended to kill, is the same as the second element of murder in the first degree with deliberate premeditation. The second and third prongs are different from any element of murder in the first degree with deliberate premeditation. The second prong is that the defendant intended to cause grievous bodily harm to Anna Walshe. Grievous bodily harm means severe injury to the body. The third prong is that the defendant intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. Let me help you understand how to analyze this third prong. You must first determine whether the defendant intended to perform the act that caused the victim's death. If you find that he intended to perform the act, you must then determine what the defendant himself actually knew about the relevant circumstances at the time he acted. Then you must determine whether, under the circumstances known to the defendant, a reasonable person would have known that the act intended by the defendant created a plain and strong likelihood that death would result. Let me give you some supplemental instructions relevant to the charge of murder. The definition of death. Death occurs when the heart has stopped long enough to result in complete and permanent loss of brain function. This complete and permanent loss of brain function occurs when, in the opinion of a licensed physician based on ordinary and acceptable standards of medical practice, there's been a total and irreversible cessation of spontaneous brain functions, and further attempts at resuscitation or continued supportive maintenance would not be successful in restoring such function. Next, the jury's obligation on guilt or innocence. You've been instructed on two theories of homicide in this case: murder in the first degree and murder in the second degree. If the evidence convinces you beyond a reasonable doubt that the defendant is guilty of a criminal offense, you have a duty to find the defendant guilty of the most serious offense that the Commonwealth has proved beyond a reasonable doubt. If the evidence does not prove beyond a reasonable doubt that the defendant is guilty of any offense charged, you must find him not guilty. Do either counsel need to see me?
No, Your Honor.
Be happy to see you.
So we have an answer. Yep, they will be able to consider second degree murder here, but it's still going to be difficult. Was there any evidence that Brian Walshe committed an act, right? That would, for example, I always think of the act. Let's say they were in an argument and they were fighting, and he just suddenly threw a beer bottle or something, or a champagne bottle, and intending to hit the wall, but it actually struck Anna in the head and killed her. That would be a dangerous act for rising to the level of second degree murder. So you will hear them. The judge just explained what that meant. So, and thank you very much. Thank you very much. But it's very interesting. So now we'll see what the jury does with it.
You take a, I know you haven't been sitting there that long, but you're going to go for a stretch now. So I'm going to ask you to stand up.
So they're going to stretch.
Shake a leg.
I just wish they would get on with it and have the closing arguments.
When you're ready,
Oh.
please be seated.
Okay, little stretch.
So, jurors, I'm about to conclude my first set of the instructions to you, and we're going to hear the closing arguments of counsel next. This is an important part of the trial because it's the final opportunity that the lawyers have to address you. It's an opportunity for the lawyers to summarize the evidence, to call your attention to certain parts of the evidence that they regard as important, and based on the evidence, to try to persuade you to reach a certain result. However, what you're about to hear is not evidence. Lawyers aren't witnesses. All of the evidence in this case has been presented to you through the testimony of the witnesses, the exhibits, stipulations, which you have before you. As to the exhibits, you'll have an opportunity to examine those in detail and consider them during your deliberations. Our rules are designed to ensure that the parties receive a fair trial, and they therefore prohibit the attorneys from making certain types of arguments in an effort to persuade you to reach a certain result or to favor or discredit either party. For example, the lawyers are not permitted to refer to facts that are not in evidence in this case. If, based on your memory and understanding of the evidence, a lawyer does this, you should disregard that comment. The attorneys are not permitted to express their personal beliefs in the credibility or lack of credibility of any witness who testified in this case. That determination is entirely for you to make. If a lawyer makes such a comment, you should disregard that comment. This case must be decided based solely on the basis of the admissible evidence and the law that I'm teaching to you. Attorneys are not permitted to persuade you for or against either party by appealing to human passions or prejudices. If a lawyer makes such a comment, you should disregard that comment. If you become conscious of any passion or prejudice as you consider the evidence and engage in your deliberations, you must put these feelings aside and not permit them to influence your thinking. With that, we'll turn to the closing arguments. As is the custom, we'll hear first from the defense. Attorney Tipton.
What could happen to a loving father and a loving husband? We're making line of peace before they search for the unspeakable on the internet. Exposed body of the woman that you adore. Government suggests it was an affair. There's no proof of that. There's no proof that Brian Walshe knew anything about an affair between the woman he loved and William Penn. Money? Second reason that the government suggests, family money? Money that the family had worked together for years and continued to talk about in text messages and the sales of property, trying to protect the assets for the benefit of the whole family and the future of their 3 children. A motive? There's no motive. Refusal to consider prison for a terrible mistake he made. The case that began in 2018. There's no proof of that he was afraid to go to prison. Who wants to go to prison? But prison was always on the table. And it was just something that he had to face up to, and something that he did. So what would cause a loving husband and a loving father to do the things that you heard about in this case? Could it be something that was sudden, something that was unexpected, something that was unbelievable, something that only a medical examiner would understand, have knowledge of, but not a man like Brian Walshe. Something that is terrifying, something that defies logic when it happens. How do we know that Mr. Walshe was a loving father and a loving husband? We know from much of the testimony of Jim Mutlow. We know from simple testimony from Julie Basler from Kindercare. When asked questions about her experience with Mr. Walshe and the children, that he would show up and he'd be interested and he'd be friendly, and he was always interested in the progress of his children. And how do we know he was a good father? Because Anna Walshe trusted him with their 3 children, 24 hours a day, 7 days a week, for all those times she was up in Washington, D.C. The unthinkable happens. It happens in a variety of ways. And the Commonwealth must prove to you beyond a reasonable doubt that a homicide occurred, that a killing occurred. Nothing proves that beyond a reasonable doubt on the facts and circumstances and the evidence presented to you. There's evidence that he lied to the police. There's evidence that he searched the internet. There's evidence that he disposed of the body. But there is no proof in all of the evidence that you have heard in Big Percent that he ever once thought about harming the woman he loved. That he ever thought about harming the woman he loved. Did he ever planned to harm? Did he ever intended to harm? So when we talk about the evidence of the affair, when we talk about evidence of financial concerns, when we talk about evidence of being ready to go to prison, those are the motives that the Commonwealth needs to prove to you to support any notion that a loving husband and a loving father would kill his wife. And the evidence suggests there was no motive at all. And without a motive, without a reason that is based on facts and circumstances, logic and understanding, without that, you have a sudden and unexpected event that results in confusion, panic, and fear. All of those things that are so troubling and horrific that you've heard evidence about, they may be argued that they show consciousness of guilt. But people do things, terrible things sometimes, not out of guilt, but out of fear, out of disbelief, out of confusion. Certainly, a loving father and a loving husband would feel guilty about what he did do. Not just about lying to the police, but what he did do in the context of what he did to the woman he loved. In a moment, in hours, and in days of confusion and disbelief and horror. But that feeling of guilt had nothing to do with the killing, because he never killed Anna Walshe. you will hear arguments that you've seen the evidence that might evoke emotion. Who wouldn't feel emotional in what you've heard, what you've seen? But your obligation, and I don't mean to sound like I'm lecturing you at all. Her Honor will instruct you on the law, and that is not my province, but you cannot base your verdict on sympathy for Honor Walsh. You can't base your verdict on anger to what Mr. Walsh did. You can't base your verdict on passion based on the evidence that you've heard that is upsetting and terrifying and at times disgusting. But that's not what you can do as jurors in this case. At the beginning of this case, when you were sworn as jurors, you might not recall it, but the clerk of this court read you some words. To this indictment, the defendant pleads not guilty. Places himself before this country which you are, the obligation that you have accepted in this case is unlike perhaps any obligation that you've ever accepted in your life. Perhaps. That's for you to judge. But your obligation requires that without passion and without anger and without sympathy, that you assess the facts as troubling as they are, and at times as horrific as they are, and make your verdict rest on the evidence and nothing less and nothing more. Unbelievable, facts that don't make sense at times, something that is incongruent. An example of that is the end of Mr. Jim Mutlow's testimony, where for almost an hour, he talked beautifully about the love between these two people, that he talked glowingly about Mr. Walsh. And then toward the end of his examination, he wanted to say something about now he was thinking there might have been some kind of problem, and reflect upon the evidence that he gave of a phone call he had with Mr. Walsh on the 4th, when the conversation was confusing to Mr. Mutlow, confusing where he kept asking what could have happened that would result in Anna Walsh leaving. The lie that Mr. Walsh was telling people out of fear that no one was going to believe him about what happened, so he lied. But consider the way that Mr. Mutlow had a terrible time trying to understand that. And why? Because he knew both of them. Because what he was thinking, why would Anna Walsh leave? They love each other. I know them both. It makes no sense. And that is what happens when something happens that is totally confusing. You just can't believe it. And you seek answers. You yearn for answers that make sense of something. And when something sudden and unexpected happens, something tragic, your ability to come to terms with it, when it's such a dynamic, such a tragedy, you change. You change. The evidence of the searches, the dark, troubling evidence of the searches. They began at 4:52 a.m. on January 1st of 2023. The first one is, how do you dispose of a body? It causes chills. It causes disgust. Look at all of those searches. Think of how they evolved. Consider how they go from one subject to another in rapid fashion. Searches conducted by a man that is in disbelief, in confusion. 5 hours spending with his wife on New Year's Eve, enjoying life, talking about the future. And then the sudden and unexpected tragedy happens, and it doesn't make sense. If Mr. Walsh began to make those searches with murder in his heart as a result of murder, then why isn't the first search how to dispose of a body after murder? Because that's the search that occurred 6 hours later. And when you see that word murder, no one would not react to that word. And certainly as jurors in this matter, you're expected to react in a way to that. What does that mean? Does that mean that he in fact murdered his wife? But think about it in context. In this case, on these facts, context matters. And so the first time the word murder is used in these horrific searches is 6 hours after they began. And I tried to ask Trooper Garino, one of the forensic specialists, as he called himself, associated with the Mass State Police. I tried to ask him, well, it's only logical, isn't it, that if you don't get results, you change the wording. We all know that from our own common experience. And you look at those searches that came and went during this time, and the results had to do with funeral parlors and cemeteries and things like that. But Mr. Walsh, given the tragedy that occurred to his wife, and given the time that had passed and his fear and disbelief, he couldn't call a funeral parlor. We need to try to understand, what can I do? Then the searches become darker. They become more upsetting. Now the thought is dismemberment. And there's searches like that. You've heard about them. You'll read about them. And then you see searches that cover days. And there's searches about cleaning. And there's searches about how to clean up. You'll read them. And even though they don't talk about murder, they are equally upsetting, because you're thinking, as jurors in this case, he's thinking about cleaning up the basement. He's thinking about how you clean a concrete floor. Context. 1,034 pages of digital data, 3,667 records taken from his MacBook. Not one record, not one page refers to any plan. Not one record, not one page refers to any intent to kill. Nothing. So keep it in context when you review that exhibit and those searches, and ask yourself, why is a man searching now if he had intended to kill his wife? Why is the man searching now if he had planned to kill his wife? And that is the government's theory. He planned. He deliberately premeditated the plan to kill his wife. Where is the evidence of premeditation in thousands of pages of records. I suggest to you respectfully, you're the jurors. What is the evidence of premeditation? There's evidence of a knife. There's evidence of a knife that is seen in a kitchen cabinet. Did I please have exhibit 201? And next exhibit 202. And finally exhibit 203. The knife. It was above a refrigerator. It was in plain view. Had no visual red blood stain. And yet the government wants you to think about this knife. So think about it. Don't ignore it. Do not refuse to consider it. Of course you will, but think about it. In a cabinet above a refrigerator. And they first test it with some screening test. It doesn't prove that it has even blood on it. And they take it, and they should. And then, what happens is everybody loses interest with the knife. Everybody, the Mass State Police, the crime lab. There's no further testing of this knife. And ask yourself, if that knife is to be considered a weapon used, then why is it in that cabinet? You have heard evidence of bags and bags being thrown in dumpsters over a period of days. The government wants you to think that Mr. Walshe killed his wife and perhaps used this knife. Then why was it sitting in a cabinet days later in open view for the police? What logic is that? And there is no proof that it had one piece of biological evidence on it tied to any killing or any harm. And they simply lost interest in it. You can take it down now. Digital data, talked about that briefly, but there is nothing in that data, all of that data. And we're talking about text messages. We're talking about backbook searches. We're talking about the life that's embodied in computers that this day and age we know apparently keep track of everything we do and to some extent everything we think about. Because that's how the government is using that data. They ask you to look at certain things and indicate and try to argue that, oh, this is what he was thinking. So look at it and judge for yourself. What's in this data that demonstrates premeditation or intent to kill or intent to harm? You have heard and seen much physical evidence. You've seen pictures of gray slippers with blood on them. You've seen pictures of all kinds that is made by the government. Something about a dark gray slipper with blood on it indicates that a murder happened because, listen to the argument, of course you will. But a theory, an opinion, does not make it true. And to suggest something like, the evidence shows that Mr. Walshe went and bought a Tyvek suit, and maybe there's just not enough blood on the Tyvek suit to satisfy the Commonwealth, and so they suggest that some killing happened, and that's why there's so much blood on that slipper and those slippers and all that other evidence. But ask yourself, what do I know about that evidence now from what we heard? Every piece of evidence was put into a bag that then was put into a compactor eventually and was pressed together and then found. And you will see all of this evidence of when they pulled it out of dumpsters and unloaded the bags, and they first put it on damp ground without any paper below it, without any tarp below it. And you heard from no less than 3 witnesses. Mr. Gould from the Mass State Police Crime Lab, Mr. Sheehan from the Mass State Police Crime Lab, and Ms. Salim from the DNA unit. They all consistently said cross-contamination or transfer. They use different terms, but they all agree. So the evidence, the physical aspect of the evidence, the thing you see in the photographs, the thing you see now, if you open up one of the bags and take things out, is not representative, or may not be representative of how it looked before. And you must consider that. So when the government makes an argument based on the state of the physical evidence as it appears now, ask yourself, maybe that makes sense, but maybe there's another way of thinking about it. And why is that important to your deliberations? Because you are allowed to rely on what's called circumstantial evidence. You're allowed to rely on inferences. And Her Honor will instruct you on that. I will not. But whatever reason and basis you have for making your choice and determining your decision must be reasonable. And if you, as jurors, talking amongst yourselves, find that some of your fellow jurors say, well, I think maybe it means this, and I believe this, and your other jurors, fellow jurors, say, I think this, and I believe this, you'll all consider it. But if you don't agree, then you have to ask yourself, is that inference reasonable? Is that circumstantial evidence built upon inference? Is that reasonable? And can I use that? And should I use that to try to reach a verdict under a standard of reasonable doubt or moral certainty? What is the evidence that something violent happened in this house? I went through every room as best I could with Mr. Sheehan. There was nothing found in the upstairs bedroom. There was nothing found in the sinks and basins, showers of multiple bathrooms. Nothing found, meaning biological evidence that might indicate something violent occurred. There was nothing found in the kitchen other than a knife that they lost interest in. There was nothing found in the living room that had padding around the fireplace to protect the children from falling. There was nothing in that bedroom where Anna Walshe, Brian Walshe, as adults, enjoyed their life together and had spent their life together, perhaps every night, before she moved to DC to take that job. How do we know that? We know that because the photographs show there was nothing there. Even what was characterized as red-brown stains on curtains in the bedroom turned out not to be blood at all. We know that because trained examiners from the Mass State Police examined probably every square inch of that house. We know that because we saw photographs in her testimony about floor that was dug up based on their experience and training. That biological evidence, like blood, can fall between the cracks of flooring and reside on the subfloor. And so they tore the floor up, and you saw those photographs, and you'll have them. And nothing was found. Nothing at all. I asked Mr. Sheehan about blood spatter, and he forthrightly and honestly said, I'm not a blood spatter expert, but he explained it sufficiently to you. Someone wielding a knife or a weapon and causes blood to let out of a body, and you look for blood that has spattered with directionality, nothing. Nothing in the bedroom, nothing in the living room, nothing in the bathrooms. No evidence that blood drained down the drains. Could I have exhibit 217, please? That test that I asked Mr. Sheehan about, the Serotek Hem test, that checks for hemoglobin, for blood. That test, he agreed, can detect blood at the sensitivity of 20 nanograms per milliliter. 20 nanograms. A nanogram, as he agreed, 1/1000th of a gram. Think of how minuscule that is. And they used that all over the house. And so the government elicited questions and answers from many of their state police, the 10 or 20. They didn't call everybody. That's up to them. But apparently there was no need to, because 10 people or more, as Mr. Sheehan had described to you, he was estimating. He was trying to be as honest as he could and credible, and he was. 10 people pouring over that house all day on January 8th. 10 more people or more pouring over that house on January 9th with their tools and their experience, and they don't find anything except multiple bloodstains. Where? In the basement. In the basement. On the concrete floor. Ask yourself, when you heard testimony that Mr. Walshe attempted to clean, and so therefore they couldn't find evidence in the other parts of the house because he cleaned it. Well, ask yourself, wait a minute. Is that logical to suggest that he cleaned the bedroom up so well nobody could find a thing? He cleaned the living room up where the rug may have been, and they couldn't find anything. Well, then you see those searches where he searches specifically for how to clean concrete. So you might infer, and it might be a reasonable inference, that he attempted to clean that concrete floor. And yet, what was found on the concrete floor? Multiple red-brown stains that turned out to be blood, and in some instances, we can all agree, based on the testimony of Ms. Celine, the profile, those blood drops matched the profile of Anna Walshe. So to suggest that Mr. Walshe did everything he could to clean the basement concrete floor with hydrogen peroxide and mops and cleaning fluids, only to have blood found on the floor, defies a reasonable inference that he was able to clean any part of that house sufficiently to avoid detection. And why is that important? Because nothing violent happened in that house. And that's why there is no biological or blood evidence anywhere in that house. The act of trying to hide the body of his wife and the blood evidence that is seen on that carpet. That's what happened. There's no blood in the living room. The inference might be that the carpet is taken downstairs. Because you can look at those pictures. You can look at the physical pieces of carpet. And you should. If there is no evidence of any killing that happened, and there's no evidence that anything was done before Mrs. Walshe died, and there's no evidence of premeditation or anything, there is evidence of lying and disposing of the body. You can take that one. So now we look at the evidence, and I'm just going to characterize it. Some of the evidence that the Commonwealth has presented to you, and there is no question that their obligation is to present to you evidence. But I just ask you to think about, in some cases, how that evidence was presented to you. And I'm going to use a phrase that may or may not be entirely accurate, but it's cherry picking. It's looking at thousands of points of data and asking you to think about it, but not telling you why you should think about it. And what am I talking about specifically? And I'll give you some examples. We already talked about the hole in the ceiling, but let's talk about it a minute. They kept talking to you about that hole in the bedroom ceiling as if it was of some significance. And yet you recall the testimony of Mr. Sheehan. I didn't see anything significant about it. It looked like somebody might have fallen through the ceiling. And there's nothing significant about the pieces that Mr. Walshe had stored in the cabinet in that same bedroom. I asked Mr. Sheehan about that. I didn't see anything significant about that. Yet you kept being given that evidence. And then as the evidence developed, for some reason, there's Mr. Murphy. And it came out in evidence that Mr. Murphy had in fact contacted Mr. Walshe because there was a promotion going on. It wasn't that Mr. Walshe said, hey, come and fix this hole, this suspicious hole. No, he was contacted. And he didn't respond right away, but then he did. And for some reason, they keep insisting that that hole is of some significance, but they don't tell you why, they just give it to you. They do the same thing with the searches. Remember when Trooper Keefe was sitting right here and he's asked to look through those thousands of, 250 pages of the search history from the iPhone Mini 13, the phone that belonged to Mr. Walshe, and he's asked to look at it and says, do you see searches there to go to the MGM? Yes, I do. Nothing else. No explanation why that is significant, why it's important to try to determine if a man committed premeditated murder. You're just throwing out pieces of evidence. Why? Why were you given? Why was Trooper Keefe asked to tell you about a song, a partial song title? And when you go over that evidence, look through there if you choose to, and I encourage you to do that. And you see song after song and movie title after movie title. Why is it that the government throws that at you and says, think about this? For what reason? And then they present to you through Trooper Garino something about a porn movie. I'll just take this opportunity right now to apologize to each and every one of you for some of the questions I asked. But it just didn't make sense that you would take that type of evidence and suggest that it has anything to do with determining whether someone committed deliberate, premeditated murder because there's a word in the title of a movie. And that's what I'm talking about, the quality of some of the evidence here, thrown at you as if it means something, that it's significant, and yet here you are being asked to determine if someone, Mr. Walsh, committed premeditated murder with a specific intent to kill the woman he loved. When we talk about premeditated murder, we talk about planning, you have to ask yourself, did I hear evidence of the conduct of a man who premeditated, a man that had thought about a killing, a man that had planned? I mean, think about what you heard. And we're not going to repeat all those things I've already said, but I want you to focus on one other piece of evidence. I asked Detective Schmidt, when you went down to the basement on January 4th, you saw some bags down in the basement. Yes, I did. What did you think was in those bags? I thought they were pieces of rug. My goodness. What does that tell you about the thinking process and the sloppiness and the lack of any planning or careful thought that you would expect out of someone who had planned a murder? And then he lets a police officer walk down in the basement, and the police officer, based on his training and experience, uses, I think he said, his boot, and he felt it, and he said, felt like pieces of rug to me. Rug that is in evidence. It has blood. Think about all of that when you're thinking about it. Did this man, Mr. Walsh, did he plan anything? No. Did he intend to kill anybody? No. Did he kill Anna Walsh? No. The evidence does not support a finding of premeditated murder with specific intent to kill based on the evidence, not based on sympathy, based on the evidence. What's some other evidence that is troubling? Mr. Walsh is talking to the police, and he says, I messenger. When asked about, and we was trying to explain it, things will come up on my phone that I thought were for me, but then it turns out they were for Anna. And so the government seizes upon that evidence and suggests that there's evidence that Mr. Walsh had seen text messages between Anna Walsh and William Fastow. And those text messages between Anna Walsh and William Fastow, some text messages are placed into evidence, and I'm sure you'll look at them. And why would the government want you to believe that Mr. Walsh saw those text messages? Because some of the entries in those text messages are very upsetting. They may very well enrage a husband to read about what was going on in those text messages. So you'll look at them. But ask yourself, as you look at them, and perhaps as you think, I could see that might upset, that might put somebody in a rage. Problem is, there is absolutely no evidence that Mr. Walsh ever saw any text message, because he was trying to say, I messenger. And now you know from the testimony of Trooper Keefe, there's no such thing as I messenger. We're talking about Facebook Messenger. But the important thing is, there is no evidence in all of the digital data that you have before you, in all the digital data that they examined, that Mr. Walsh ever saw anything going on between his wife and William Fastow. And when you look at those text messages, and you might have some question about it, if the government stands up and says, well, he saw those because he told them that he was seeing iMessenger, which doesn't exist, then ask yourself, why is it then that on New Year's Eve, Anna Walsh is taking all these photographs? It's festive. It's a lovely situation. And she says, in the presence of Brian Walsh, as she and Jim Mutlow were taking photographs, hey, why don't we send a photograph to Will Fasto? And was there any evidence that he reacted, Mr. Walsh? No. And when asked by Attorney Porges, well, so what happened next? And Mr. Mutlow really took efforts to remember, and then he said, oh yeah, that happened before the young boy woke up and came downstairs, and that was around 10:30. So if you just think about that, then the festive and jovial celebration continued for another 2 hours. There is no evidence that he reacted. Mr. Walsh reacted to them sending a photo. Why? Because he knew his wife had a crush on Will Fasto, and it didn't even make him jealous. And how do we know that? Because she told her friend, Alyssa Kirby. And Alyssa Kirby was asked, and she said, you know, Anna told me that he didn't get jealous. He's not the jealous type. In fact, I wish he was more jealous. Please consider that in the context of this notion that the motive for a killing that did not occur, but the Commonwealth's theory of a motive is anger over an affair. There's no evidence of that. Dr. Atkinson told you. Dr. Atkinson described to you the phenomenon of sudden unexpected death. It happens. Just because it's rare, and just because the government will undoubtedly argue that that is nonsense, listen to their argument. But Dr. Atkinson made it clear it happens. It happens in young and old, male and female. It happens unexpectedly. In fact, it happens with people who have never manifested any problem before. It happens in athletes. And how do we know that it's not absurd, even though it might be rare? How do we know it is an important aspect of what happens to people? Because the laws of this state mandate that the office, the chief medical examiner, get information from doctors, police officers, nurses, when there is a sudden death, when someone is otherwise healthy. They're mandated to investigate that. So there is a statute that Dr. Atkinson told you a little bit about on cross-examination. So ask yourself, is it as unlikely? Is it bizarre? Because Anna Walsh worked out. Yes, she had been sick before. She had been with Alyssa Kirby in the days leading up to this, and Alyssa Kirby wound up having the flu. But that's not what really is at issue here. Sudden and unexpected death may occur because someone is ill. All we know is that it happens. And the fact that someone doesn't believe it could happen doesn't mean that it doesn't. Importantly, though, think about the shock of it happening. Think about the effect it would have on anyone. A lay person that has no idea it could happen. You're down celebrating with your wife and your friend, and then the tragedy happens. And you panic because you can't believe it. You don't understand it. And you don't think anybody's going to believe it. Context. I walked Trooper Keith through all of that information, something that he had not done yet. And so what did you hear? We went methodically. Sometimes, I'm sure for some of you, it was a little painful. It took a little while. But we went through hour by hour, day by day, that basically was the life and the experience that Anna Walsh and her husband, Brian Walsh, were going through in just the days leading up to January 1st of 2023. And what do you see? And you'll have that evidence. You won't have it compiled in the way that I presented it to you, because Trooper Keefe never saw fit to assemble it in a way where you could really see what was going on. But what do you see, and what did you learn from the evidence? Two people communicating by phone and by text, talking about sales of property, talking about investments, talking about the future, talking about reinvesting, talking about buying new property in DC, talking about all of that, and it's all in the text. Joking when Anna Walshe was ill and stayed home and told her husband that in the text. And then they joke about it. I'll get you a plunger. And she responds, it's right there on the text. Joking back and forth in the days leading up to New Year's Eve. I'll tell you what, I'll buy the plunger. You buy me a Porsche. And then you see him shopping for a Porsche for the woman that he loved. How does it go from, I'm going to find you the Porsche you want, that speaks once again to the financial issues that were non-existent? How does it go from that to someone who is purportedly premeditating and intending to kill his wife? And those texts lead right up until she arrives by plane in Cohasset to celebrate. So, context. Once again, divorce. About 11 minutes of talking about divorce and searching about divorce in 7 days of phone calls. And how did that divorce search come up? It came up in the context of protecting the family assets because they just sold the house in Revere that Jim Mutlow told you about. And they're trying to protect it. And the thought is to roll it over in a 1053C. And Mr. Mutlow explained that to you. Planning for the future. That is the relationship between Brian Walshe and Anna Walshe in the days leading up to January 1st. So now we have come to just the evidence that, once again, just explains their relationship. Not supposition. Not trying to make up what they said to each other. You have that in their text. You have that. Then we get to New Year's Eve. We get to a festive event, jovial, laughter, love, described in various terms, various ways, not for 30 minutes, not for 1 hour, but for 5 or 6 hours. Laughter, talking about the future. Jim Mutlow described it for you. Brian Walshe cooking, standing across from the island, feeding both of them, talking, laughing. You see in the testimony that, yes, there was an affair. He didn't know it. He loved his wife. He treated his wife like the wife he loved, the mother of his children, until the sudden, unexpected event happened. Imagine you are so in love. You support your wife to get a job in DC. You're going to take care of the kids because, one, you love your children, but you want to take care of them. You want to share property and protect the assets, so everything goes into her name to protect it because he has this federal case. So let's protect our financials for the future. And then you hear the testimony of Alyssa Kirby. Yes, she was upset. There's no doubt Anna Walshe was upset. What exactly she was upset about? Maybe things weren't going really well in the affair she was having. Or maybe she was, in fact, stressed out. Who wouldn't be? They were living apart. She wasn't seeing her children. Now, maybe, it's up to her. Anna Walshe was a wonderful person and a wonderful mother. And that's why he loved her so much. But she had another life, and she went to Dublin, and that's another piece of evidence. They want to suggest to you he knows something about Dublin. Where is the evidence of that? None. And you hear Alyssa Kirby choked up with tears, sobbing on the stand. but nonetheless recalling a conversation she had on 12/29, 3 days before January 1st. What does Anna tell him? Well, I don't know if I love them as much as I used to. Those are her words. I'm paraphrasing, but that was the gist of it. But I want him to take responsibility. Why? Not so she could kick him out, not so she could leave him, so they could reunite as a family. That was what Anna Walshe was talking about. That's what she was thinking, even though she was stressed, even though she was upset. And things like that happen in families, but families make it through. And that's what she was expressing. That's what she was expressing to her best friend, Alyssa. Could I have exhibit 169, please? We are now at the end of the New Year's Eve party, and they sign the champagne party. We're talking about the feelings and the emotions and the state of mind of Anna Walshe and Brian Walshe, and looking towards the future. And this is on January 1st. This is on the day that the tragedy happened. Can you find it? I'm sorry, 169. Oh, I apologize. My fault. I'm sorry. Exhibit 257. And that's the champagne box that was signed. And what are the words? What a year. And yet we are still here and together. Let's make 2023 the best one yet. We are the authors of our lives. Courage, love, perseverance, compassion. Those are the words of Anna Walshe talking to her husband. Look what she says. What a year, and yet we are still here. What does that tell you? Yes, they had been through a lot. She missed her children. What mother wouldn't? But they were working toward the future. And one final thing about the state of mind of Brian Walshe at this period of time. He made reservations for a New Year's Day dinner so he could be alone with his wife. And the evidence of that is in these records. And I'm not going to have it called up. I'll just tell you. Exhibit 79, page 186, record 682. That's the data. He's researching where to take her out. And you'll see a reference to Nightingale, a restaurant that I asked Trooper Keith about. A restaurant that's right on the line of Marblehead and Lynn. Exhibit 59, at 12:27, those records indicate that Mr. Walshe credit card used to reserve dinner for $573.76. So him and Anna could spend New Year's Day celebrating. And exhibit 170, a text from Nightshade Restaurant itself acknowledging the reservation. And those were the plans that he made. And the government will suggest that's some kind of evidence of premeditation. Well, it's not any evidence of anything but love. And I'll just tell you, when you look at that evidence, you'll see that that email exchange was deleted. It's right there in the evidence. And then you heard the federal probation officer saying he wouldn't be allowed to go there. He'd have to get permission. So yes, did Mr. Walshe lie to his probation officer for what reason? So he could take his wife out for a New Year's dinner, and that evidence, and the evidence that you saw in that champagne box, is what their life was right at the moment before the tragedy happened. That is the evidence. I'm sorry I talked for so long. I apologize. Mr. Walshe loved Anna Walshe, the mother of his 3 children. There's no evidence that he deliberately premeditated a murder. There's no evidence that he ever intended to kill Anna Walshe. None whatsoever. Mr. Walshe is not guilty. He's not guilty of murder. Thank you.
Jurors can't, why don't you take a moment to stand up?
Wow. I'm not sure if Jen is here or not. I'm going to add her to the stage anyway.
Everyone good?
But, you know, Tipton, I think, he went over, but he did the best he could possibly do with what he has. Again,
And you're ready.
trying to say over and over that his client did all these heinous acts, yet he loved his wife. He panicked. And where's the evidence that he intended to kill her? Where's the evidence of the pre-planning? Where's the evidence of the premeditation? So that's my thought.
Are they
And
still going here? Can't tell. No, they're on break, right?
here we go with the prosecution's opening. The prosecution, I'm closing. The prosecution always closes last because they have the burden of proof. And now I will get down.
You may proceed.
Anna Walshe is dead. Anna Walshe is dead because he murdered her. And he intended her death. Anna Walshe is not missing. She never walked out of her class at home on January 1st of 2023 between 6 and 7 a.m. to take an Uber to Logan Airport. She wasn't going to DC for a work emergency. There was no emergency. She didn't say goodbye to her son. That's just a story that the defendant told people. But since January 1st, Anna Walshe has not been seen by her friends, her coworkers, or by the people who loved her. Anna didn't take an Uber. She didn't take a Lyft. She hasn't used her phone. Her phone's had no contact with the Verizon network since January 2nd, 2023, when it was in the vicinity of 516 Chief Justice Cushing Highway. She hasn't used her bank accounts, her passports, her credit cards, her email. She didn't vanish. The defendant was the only adult at 516 Chief Justice Cushing Highway after Jim Lulu left around 1:30 a.m. on New Year's Day. After he left, Anna was home alone with the defendant and their 3 sons, ages 2, 4, and 6. This defendant caused Anna's death, and the evidence does show you that. The evidence shows you that Anna didn't die of natural causes, but that Anna died a violent death in her Cohasset home on January 1st. You have the photos of those pieces of rug recovered from the dumpster at the defendant's mother's complex. The rug that had been in the living room. You have the photo of Anna in the living room on top of the rug. And the photo shows that there are wood floors in that room. There's blood on that rug. The rug was recovered from the compactor outside of the defendant's mother's apartment and taken to the office of the chief medical examiner for examination. And Dr. Atkinson found a blood clot and a piece of Anna's Gucci necklace embedded in one of the cut up pieces of rug. So look at the piece of metal stamped Gucci. It didn't break on its own. The rest of the necklace is missing. This is the necklace that Will Fastow said that Anna often wore. Look at the slippers from the dumpster. The 2 pairs of adult slippers. The dark gray slippers have hair and blood clumped to the bottom. And the DNA testing tells you that the slippers had the DNA of Anna Walshe and the DNA of the defendant. Then there's the bathrobe. And there are 2 bloody white towels. A towel was tested and had Anna's DNA. Why did the defendant throw those items out? Because they had Anna's blood on them. And the evidence shows you this, because the defendant was researching cleaning. How to clean blood from what floors? Does the dishwasher clean blood? Is it possible to clean DNA off knife? The defendant still had a cut on his thumb on January 9th, 2023. And on January 1st, before he even went to Lowe's to buy any cutting instruments, an initial stop that he made when he left his house was to go to Walgreens to buy antibiotic ointment and Band-Aids. Then he went to Vin and Liquors, where the manager identified the defendant, and the defendant threw a bag into the dumpster. Store is closed. The parking lot is empty. He's not yet gone to Lowe's. On January 2nd of 2023, the defendant went to Home Goods because he had to buy a new rug for that living room to cover the hardwood floor. He did this days before the forensic scientists got to the house and knew that the rug had been changed. Anna Walshe dying a sudden death from natural causes defies common sense. She was in great shape. The defendant told police that Anna was a sturdy Serbian woman. Listen carefully to his recorded interviews, because those are his words after her death, after he killed her. Mark Salvaggi told you that Anna had the highest health rating of the life insurance company. Anna had to complete an interview, have blood drawn, provide her medical records, and the life insurance company and the underwriters gave her this health rating. Anna was an active person who took care of her health. Ashley Slamino, her bar instructor, told you about this exercise class that she took the morning of December 31st, 2022. And Anna was the type of person, she said, who made others want to work harder in their exercise class. Will Fastow told you that Anna was very active and did yoga together. Sergeant Amy Waterman described Anna's home gym in BC. And Dr. Atkinson told you about the different ways a person can die, and that it's extremely rare for a 39-year-old in good health to suddenly die of unknown causes. But without a body, it's not possible for the medical examiner to tell you the exact cause of Anna Walshe's death. No autopsy can be done. The defendant deliberately got rid of Anna Walshe's body. The defendant did not want anyone to find Anna's body and to know how she died. So the defendant bought cutting tools at Lowe's and Home Depot, and he cut up Anna's body, the woman that he claimed to love, and he threw her into dumpsters. He was hiding her body. The defendant intended to kill Anna Walshe. He didn't just want her dead, he needed her dead. This was a marriage in crisis, and it was heading towards a breaking point. It began with the defendant's federal case. And through the defendant's interview and his federal probation officer, you learned that the defendant was on home confinement. He was going to have to pay over $400,000 in restitution, and the case had been pending since 2018. You also learned that the defendant had no assets. He told Jamulu that he only made $50,000 to $60,000 that year, but he had told the police that he had businesses that were not making any money at all yet. Peter Capozoli told you that the defendant's mother had signed the lease for the Cohasset home, and it was his mother that was paying his rent. Meanwhile, Anna was beginning to thrive. The marriage was beginning to deteriorate. Anna had her dream job. She had risen to become an executive at Tishman Speyer, and she was making close to $300,000 a year. She earned a bonus. And Teresa Marchese said that Anna was a good employee. And the defendant knew this. He bragged of her bonus and salary. She bought a townhouse, and she furnished that townhouse for her family, and she set up bedrooms for each of her 3 boys. But the reality was, the family couldn't join her because the defendant needed the children with him. Being the primary caregiver allowed him to avoid prison. The separation of the defendant and Anna was taking a toll. Anna wanted the children with her, and Anna began a relationship with Will Fastow, which became more serious. The defendant and Anna were growing apart emotionally and physically. Anna struggled not having her children and not being able to be the mother that she wanted to be. This got worse when Anna took the trip to Serbia to take care of her sick mother. Anna and Will Fastow spent the Thanksgiving holiday first in Dublin before Anna went to Serbia. And Anna bought her plane ticket with the credit card that the defendant monitored. And the defendant told police that he monitored their joint Chase Freedom credit card statement. The MacBook history also shows the defendant looking at the Chase account. The defendant knew about Anna's travel because in a recorded interview, he told the police that she had a layover in Frankfurt, and that connection in Frankfurt is on the same credit card statement. And you can see that, it's right in front of you. The defendant was angry about Anna missing Thanksgiving, and he mentioned it repeatedly when he spoke to investigators.
I got angry about Thanksgiving, and then I realized it was just sad that we're not spending a lot of time together. And she was sad about it too, and it was exhausting for both of us. It was she was away from the boys, I was always dealing with the boys.
Anna returned from Serbia in December, but she only spent 1 day in Cohasset. And she was supposed to come home for Christmas morning, but she missed her early flight, and she couldn't get a flight, and then she had to drive up. The defendant told police there was an argument.
I did have an argument with her for the Thanksgiving and the Christmas Eve, so I wasn't going to make the same mistake 3 times.
So what did the defendant do on Christmas Day when his wife wasn't home? He looked up Will Fastow on his cell phone. The man his wife had just spent the night with The defendant was losing Anna. Anna was missing her children and wanted to be them. Anna quickly returned to DC, and on December 27th, the defendant was looking up the best strategies to divorce for a man and the DC divorce laws. This was not to protect assets. That wasn't the search. The defendant told the police that everything was in Anna's name. The defendant had nothing without Anna and the kids. And on December 29th, Anna spoke with Jen and and told him that she was upset about the travel, upset being separated from the children, upset about the defendant's federal case. It was ongoing. It's getting to be too much. On December 29th, Anna went out with Alyssa Purdy, and she broke down. This strong Serbian woman who was supposed to be having a fun night out with her girlfriend, going to dance karaoke, instead broke down. Anna told Alyssa that she had told the defendant that he needed to take responsibility for the federal case, go to prison. She wanted the children with her in DC, and she and the defendant had not been intimate in close to a year. In Anna's mind, the marriage was broken. Anna even questioned if she could just take the children because she had already established a separate household. She said that she was falling out of love with the defendant. And at home in Cohasset, what was the defendant doing? He was looking up the Mazda building and the FBI raid on the Crossing building. Looking up something that had happened in the spring of 2022 when Anna first started working for Tishman's Fire. Interestingly, this was when the defendant brought up something he brought up in his interviews when he lied about Anna having to leave early for a work emergency. He was planning the work emergency. The defendant was going to lose Anna, and when he lost Anna, he would probably lose his freedom. Anna would have a house in DC and a nice job, and he would likely go to jail. So the defendant pretended. He lulled Anna into thinking that everything was okay. He joked with her about a Porsche. He didn't want her to realize that he was aware of the relationship with Will or her ability to leave him. He wasn't going to let Anna know that she wasn't safe. On December 31st of 2022, the defendant claimed that he could not find his phone. Why is that important? The mislaid phone allowed the defendant to be unavailable for 2 days. The mislaid phone allowed him to carry out his plan uninterrupted. And the mislaid phone allowed him to show the police when he eventually reports Anna as a missing person and not have the police question why he didn't contact Anna earlier. The evidence shows that the defendant was methodical. Just look at how he shopped at Lowe's with a list. He planned it with precision. So Jem Lulu came over for dinner on New Year's Eve, and the defendant told Jem that his phone was lost and it was free. Anna was texting throughout the night, including with Will Fastow. This is now the third holiday where Anna was concentrating on the other man in her life. When Jem left, Anna was alone. She was with the defendant, the man she was cheating on, the man she was telling to take responsibility for his actions, and the man who had her children. The defendant murdered Anna that morning in their Cohasset home. And this is what the internet history shows. His internet history, written words, he was looking at best way to dispose of a body. Better to throw away crime scene clothes or wash them. Crime scene. Can you be charged with murder without a body? Anna was dead. The defendant killed her, and he began researching how to get her money, how to inherit, how to get away with the crime. And he might have gotten away with it, but he didn't know that his MacBook was syncing with his son's iPad, the same Apple ID. His demeanor changed during the interview on January 8th when the police mentioned the searches on the iPad. Not because the iPad involved his children. He had already involved the children in his lives, but because he knew he was caught. We know he had already involved the 6-year-old when he had the 6-year-old say that he saw his mother when she left the house on the morning of January 1st. The son could not have seen Anna leave the house. The defendant had already killed her. Listen to the recorded interviews. During the January 5th interview, the defendant spoke about what his son supposedly had seen. And the defendant involved the 4-year-old by saying that the 4-year-old hid the defendant's iPhone 13 mini. So, the defendant's phone made a reservation at Nightshade Noodle Bar for New Year's Day. After the defendant told Anna that they were going to have a special party. This is ironic because the defendant was very clear with police on January 7th that he and Anna had no plans for New Year's Day, and the defendant also knew that he would be violating the terms of his federal probation by going to a restaurant on New Year's Day. But let's look closely at Exhibit 170 about the Nightshade Noodle reservation, which was on the defendant's iPhone Mini 13, which the defense just said was deleted. And if you look on page 2, on the bottom of one of the bubbles, you will see that the message was deleted on January 1st at 7:59 and 5 seconds a.m. This happens to be one of the times that the iPhone Mini 13 was unlocked when it was supposed to be missing. The forensics show that the defendant's phone was unlocked 4 times and it was plugged in on January 1st. You heard testimony that the phone had a password of 197512. And in the January 4th recorded interview, you hear the oldest child needed help with his iPad password, which was 121212. The children didn't unlock the defendant's phone. The defendant blamed his misplaced phone on one of his children when he said that the children hid it. But it makes no sense that a 4-year-old somehow unlocked the defendant's phone and deleted that text reminder. Listen to the defendant's recorded interview. The deletion is made when the defendant is supposedly making French toast and playing with the kids. The defendant had access to his phone. Context. The defendant also had access to 2 other phones when his phone was supposedly lost. He had Anna's phone and he had the iPhone SE. And in the recorded interviews, the defendant told police that on New Year's Eve, Anna had an argument with a friend, and as a result, Anna put her phone upstairs in his bedroom.
You said she went and put her phone upstairs after that?
After that, she, let's say it's 10 or 15, then I remember her putting her phone upstairs because then she came back down without it.
Was, Thomas came down at one point and hung out with you?
Yes. Yeah, exactly.
Was this before, during, or after Thomas was participating?
Oh, yeah, Thomas went to bed at, he went to bed, then he came over at like 9 or 10 or something. I think Anna took a bunch of photos. Jem and I don't have any because she didn't send them to us yet. But I think she sent one to Will Fasto. So that was that's when the photo was taken about. So it's maybe 10 o'clock or something like that.
You know where upstairs she put her phone at that point?
Yeah, on a bedstand.
That's not what Jem said. Jem said that Anna was using her phone all night. Melissa Kirby texted with Anna. The defendant was telling investigators a story about Anna's phone. How else do we know that the defendant intended to kill Anna and had a plan for doing so? Look at his internet history. Look at what he did. The defendant set up an area in his basement where he surrounded it with plastic sheeting or a tie-back suit and dismember his wife, the love of his life. Hacksaw, the best tool for dismembering a body. Then the defendant got rid of Anna's body. He got rid of her belongings. He got rid of her clothes and bag that he told police that she had, that she supposedly left on January 1st. He threw her in the garbage bags, tossed those garbage bags in different dumpsters, disposing of a body in the trash. Chatham West apartment rental, the Claremont apartment rental. And police confirmed this with the location data from the SE phone and the iPhone 13 mini. The evidence shows that the defendant did this to hide the fact that he murdered Anna. He could not let Anna's body be found because Anna didn't die of natural causes. The defendant murdered Anna, and then he had to hide the evidence of his crime. In his mindset, within his internet history, want to get away with murder, use a special detergent. Can you be charged with murder without a body? Best way to dispose of body parts after murder. When you deliberate, look through the binder of the MacBook internet history. There are no searches of natural causes of death, sudden death, heart attack, aneurysm, stroke, or how to help your children when someone dies unexpectedly or goes missing. The defendant was not sad. Look at his demeanor in the surveillance videos. He's cool and calculating. He's calm. He had a plan. On January 1st, he went to the Lowe's store an hour away, even though there were hardware stores approximately a mile from his house. And when he was in Lowe's on January 1st, he wore a mask and he wore gloves and he had a list of what he was shopping for. He was calm as he helped bag the purchases. A hacksaw, buckets. He used cash. Does this show confusion, panic, or fear? But he doesn't stop there. He went to CVS to buy hydrogen peroxide, and then he went to Stop and Shop to buy ammonia. No wonder the house was so clean. And on Monday, January 2nd, he went to Home Goods for rugs and candles. And then he went to Home Depot, where he had bought buckets with lids this time, baking soda, and a hatchet. And at some point that day, he got a call from his probation officer, and he lied, and he said that he was picking up his children. He was able to calmly Speak with her. No panic. He had everything now that he needed to dismember the woman that he supposedly loved. And he started to take her body and to throw it into dumpsters, as he had to cover up the crime to get rid of the evidence of the murder. This was not a man in crisis. This was a man who on January 4th went to TJ Maxx to buy pants with the store exchange card. He was calm. But Alyssa Kirby texted him on January 4th asking about Anna. And so he called Tishman's Fire a few minutes later and started to pretend to look for her. He called Will Fastel, but he didn't leave a message. He called back later, and then he calmly left a voicemail. No panic. The defendant knew where Anna was. The defendant even texted Anna's sister in Canada and said that she was missing. He was methodical. Look at the text messages. And at 4:30 p.m. on January 4th, the defendant went to Lowe's to buy a trash can. Comfortable, not panicked. The police were coming to the house soon to talk about Anna. And the defendant had the house ready. The police think his wife is in D.C. He had his phone records ready, and he sent text messages to Anna, even though he knew she would never see him. Despite everything that he had done, on January 2nd, the defendant wrote a text message to Anna. I still love you. Ha ha. His joke. The defendant prevented anyone from ever finding Anna's body. There was no autopsy. Dr. Atkinson told you that the medical examiner can't do an autopsy without a body. And all that remains of Anna are 2 hairs, some blood, and a few things that belong to her. Part of a necklace she often wore, her hunter boots, a black jacket, a purse, her COVID card, and a few other items in the dumpster in his mother's apartment complex. The defendant searched his MacBook for a murder conviction without a body. Please do not allow the defendant's self-serving act of dismembering and disposing of Anna's body to let him get away with this murder. At the start of this trial, we asked you to use your common sense. When you do that, when you analyze the evidence as you deliberate and continue to use your common sense, you will see that the evidence shows there is only one verdict. Find the defendant is guilty of the premeditated first-degree murder of Anna Walshe. Thank you.
I will see counsel at the side of the bench.
Well, in my opinion, the delivery wasn't phenomenal, but she did get her points across, and she did try to show the jury, listen, these are the pieces of circumstantial evidence, the breadcrumbs you guys can put together to show that Brian Walshe covered up a murder, that he murdered his wife and then he covered it up. So we shall see. I don't think Kevin's back. I'm not sure. Maybe Jen is back. Let me see. Jen, are you back?
I am here. Yes,
Yeah.
listening to closing.
Wow, what an amazing! What do you think about the closing arguments? I thought Tipton gave a better delivery. He, of course, it's hard. He has a tough case to work with, but and that she was standing behind the podium looking at her notes the whole time. Not the greatest delivery, but I do think she
You're my
made valid
guidepost.
points.
You need a break for the bathroom? Okay.
Oh,
All
good.
for one for all.
We can talk.
Okay, so they need a break. Yeah, you know,
Come back out. I'll be at yours.
I'll wait till she finishes.
All rise, please.
I'm not sure if Kevin's back.
Cheers,
Kevin, are you
Walshe.
there? No. Okay.
So I think as far as the defense, I thought he made a huge mistake outlining all the prosecution's breadcrumbs and then saying, but disregard them. It was really jaw dropping to me. I think it was a big mistake because now they're going to hear the breadcrumbs twice. So he went over, the knife. He talks about the searches. He should not have focused on the most damning evidence. So
Yeah.
while he has a more engaging side, I thought his choice.
We'll give you a quick break as well, but something's been on my mind that I want to discuss now that the closing arguments are over. And that is, I had asked in connection, this relates to the sentencing, at least for the other two counts, and asked the Commonwealth to provide victim impact statements for any immediate family members of Anna Walshe that wish to provide information. And I haven't received that yet. And there might be a good reason for that. I had told you that I was putting off the sentencing until we had a verdict on the charge of murder. But now that it's a Friday and I don't want this to linger over into the next week, has the Commonwealth heard back from the Department of Children and Family Services?
Your Honor, we've been in touch with them. They are working on their impact statement. They were hoping to have the impact statement impounded. And I can, as soon as we're done here with the charge, I will speak to the attorney that I've been dealing with. They've been working very hard on this. They're certainly worried about their privacy interests of the children and the
I think there's a
social
valid privacy interest of the children, and I'm highly likely to impound it, obviously, with the exception of counsel for both sides being able to see it so that they can make appropriate arguments as a result of the victim impact statement.
I think the department will be very happy to hear that. And they also, much of what they have is through a social worker privilege, so they're concerned about that as well. But as soon as we break, I will be happy to have that conversation.
Well, I'm happy to hear that there's forward progress because I guess I assumed, because I hadn't heard anything, that you were still not getting the answers to the questions you were asking.
No, quite the opposite. They've been working very hard on this.
All right, I appreciate that.
Thank you.
Anything anyone needs before I step off the bench briefly? Thank you.
All rise.
So, speaking of the children, I think Brian's mother has had an influence with the department. And I think I bet you she's, I don't know. I bet she's tried to interfere with that impact statement. And that's just from inside information that I really can't share, that I think she's not good for the children. Let's just put it that way. What do you think, Jen? So are you still there?
Oh yeah, no,
Oh.
I'm here. So back to, and then I'll go on to those text statements, but back to the defense. He had nothing to work with, but the last thing he should have done was lined up the breadcrumbs again. I thought that was just, it made no sense to me. I think he should have focused on the small things he had, like he did touch on it, the information from the ME. I mean, basically, whether it was planned or not, Brian Walshe completely put him in a terrible state because he could not present all the things that Brian Walshe would have said, that he could have said was at least in for evidence for consideration. So by him not testifying, it really hurt the ability of the defense attorney. But at least he had passion and, walked around he was much more animated is the word I'm looking for. The prosecutor, I like that she came out and tried to do kind of the, dramatic, And this is why Anna isn't here.
Yeah, pointing at the defendant. Yeah, I used to point at the defendant too.
At the
Mhm.
beginning, but it seemed contrived. I mean, she
Yeah,
doesn't have sort of that, you know, um,
anger.
well, she doesn't, yeah, she's not really an actress.
No.
And she was trying to do that whole scene. So it came off to me kind of silly. But she has all the facts. It was disappointing that anytime they read, I want to see the lawyers, like both Brennan and I'll give AJ credit here,
Yeah.
walking around, they know their case inside out. They look at that jury, they make eye contact with each juror. They know their statement inside and out. I will say that these attorneys, I feel bad for them. First of all, this trial was really cut short when the defense decided to put on no defense. So I think they were dealing with getting their jury instructions together. They were dealing with writing their closings, which, as you know, defense attorneys will put that off till the end. And I think they thought they had probably another week. And then, now we're talking about the impact statements that they also needed to provide. And this judge is basically saying, I want this over, which makes me think that she thinks we're going to get a verdict today or tomorrow. Because I think she'll ask if they want to stay over till tomorrow to get this verdict done. And she wants to get this off.
Yeah.
So not to blab on too much, but that was my thoughts on all three issues.
Yeah, no, I agree with you there. The only thing I will say is I think Tipton was using the strategy that he was anticipating what the prosecution would say, and he wanted to address each of those issues with the jury. And from the evidence of the knife, and he wanted to say, yeah, he's almost because. First of all, the jury really isn't trusting him because he made promises in his opening statement that he didn't keep. But I think he's went through each piece of evidence that was strong for the prosecution, saying, yeah, they'll tell you about this, but it really isn't going to first-degree murder, to the level of first-degree murder and intent and premeditation. So I think he was trying to make a counter argument as to what he anticipated. It's a tough case to make a closing argument on when, here's this guy that dismembered the wife that he supposedly loved and put her in trash bags. And it's really, and I'm sure he's reading the jurors. And when I was there, the jurors appeared very grim. And I think that Brian Walshe also read the jurors, and he was like, oh my God, I'm not getting up there. Forget it. White flag. I'm done. But I think he had to address some of those points that the jurors were looking for him to address. That's all.
Yeah, and maybe so. Like you said, it's a tough job when you have bad facts. And he had bad facts.
Yeah. Yeah. Yeah, he did. He did. And as we pointed out yesterday, he looked so defeated at the end. I mean, the whole defense team did. I think they just found out that Brian changed his mind. And, and I'm sure they had an entire direct examination planned out, just like the prosecution had an entire cross-examination planned out. The judge had her instructions planned out as to Brian testifying. So everybody got surprised. It was a surprise attack as far as I can see it. So,
yeah,
I disagree with let's see, somebody else said, I disagree with the state of the Commonwealth. It was very poor. Okay. I like it when we have open our disagreements over what we heard or different strategies attorneys may have employed. Maureen, what did you think about Tipton's closing argument, given what he had to work with? I'd like to see and let's see. As to the boys, there's a difference between having boys in the care of a family member with no state and court oversight and having a judge grant third-party custody with oversight. Yeah. Yeah, true.
Yeah, all in all, I don't think the Commonwealth did a bad job in terms of they presented the facts and knew the fact. It was more of a delivery thing for me. So it wasn't that she didn't piece together what needed to be put out there, because she did.
Mm-hmm.
I still wanted to see some other points more emphasized, like the murder used in those Google searches. I probably would have started off with that.
I was thinking, you're absolutely right. So that was her strongest, one of the strongest pieces of evidence all along. And she could have really had that as a thread running through her entire argument. Sometimes you pick something memorable as a real thread, and you keep bringing it up. And, I wish she had done that. But I also agree with you. She did methodically go through the pieces of evidence that were in favor of the circumstantial case that they have, so that she's hoping that methodically, just like she did, jurors will put the puzzle piece together, each little piece of circumstantial evidence, to make the whole puzzle that Brian murdered his wife. And he planned it, even though it didn't have to be a period of planning. He got that knife, he stabbed her. Then she mentioned the broken necklace. That was big. But, emphasize the intent.
The slippers, the knife.
Mhm.
And I will agree with Miranda. Miranda is definitely somebody I love. She's on not only on the channel, but in my Twitter all the time. And I always love her feedback. She says, oh, good, I'm glad you put that up. She mentioned it a lot, but I'm talking about those punch statements from the beginning. Yes, she turned and she said, Anna's not here because of him.
Mhm.
And she's doing her best, but and that's not either of these prosecutors' style. They don't have sort of the gift of gab, the gift of being more, inserting emotion into their and that's fine. A lot of people like that Adam Lally, I'll refer to him, type style that's more dry, but it can be effective because it has all the facts. But me, I personally like the Hank Brennan style, where he's got it memorized and he makes points of the most critical pieces and then goes back and pieces them. It's the grab them with the intro, string it together briefly because they've already heard it, and then hit them with the punch at the end. We didn't really see that here, but she certainly put the breadcrumbs out there, as the judge noted. Also, did you guys talk about this when I was on Court TV? Judge Erskine brought up that they actually added the second-degree murder. That is huge, game changer, because now it gives the jury an out.
Yeah. So basically, we talked about it in chat. Okay. And the judge obviously decided on her own that there was enough supporting evidence to give that second-degree murder instruction. And she did, which is very interesting. So, and you notice too, I noticed anyway, in the closing argument for the Commonwealth, she didn't mention, they're looking for first degree. She didn't even mention anything about second degree, if you notice that. They're looking for murder in the first degree. So.
100%. That I agree with you. You hit the nail on the head. They don't want that for sure, but it's interesting that they put it in. Maybe they're a little worried, because if they weren't worried, they wouldn't have put it in.
Right. Tipton had very little to go by. He should not have brought up specifics. So Maureen agrees with you. I just think he had to mention something, because jurors are going to think, well, they'll go back to the jury deliberation room, or they'll be thinking, well, Tipton, what do you say about the knife? But Tipton, what do you say about these Google searches? And Tipton, what do you say about this? So I think he had to somehow address those bad things, because it shows that he's being forthright. That's what I'm thinking is why he chose to go to those lengths.
Well, for instance, on the knife, if he wanted to bring up the knife, why didn't he say something like this? That the knife, the Commonwealth didn't even prove that blood was from that incident. She could have been paring up an apple and nicked her finger on it. To say,
right.
Make this extrapolation that they've done it with everything. That's probably what I would have done. Something like that.
Right.
Not that it would have worked.
Yep. So Maui thinks the Commonwealth is confident that they proved murder one. I hope you're right. That is the statute, by the way. But the judge had to clarify that, you know, and she did in the instructions. And she talked about the act.
All rise to the court, please. Jurors entering.
Which we heard about in the Karen Reed trial. We heard a lot about second-degree murder and the jury instructions. I'm trying to put up the comments here. Simply say the knife was in the kitchen. Oh, what about the rug? I didn't hear anybody testify about that the rug was in the living room. That was news to me. And did you hear that, Jen? The prosecutor brought it up in her closing argument.
Oh, yeah.
The rug was in the living room.
It was brought up because remember they got the photo in of the living room where the rug was.
Oh God, I don't remember that. I missed that one.
Instructions,
Okay.
the final stage.
Jeez.
Of this
It takes a village.
we'll get the case to delivery.
I must have had a bathroom break for that.
That the second part of the instructions is to give you some assistance in determining how you go about deciding whether the Commonwealth has proven each element of the indictment is true beyond a reasonable doubt. For the charge, you must decide whether the Commonwealth has proved beyond a reasonable doubt that the defendant is guilty of the charge. You may not find the defendant guilty on the charge just because you think the defendant did something else that was wrong or improper. Your decision as to the charge must be unanimous, meaning that all 12 deliberating jurors must agree. You will receive one verdict slip. When all 12 jurors agree on the verdict, the foreperson should check off that verdict and then sign and date the verdict slip in ink. In a little while, I'll go over that verdict slip a little bit more. For the charge, if you all agree that the Commonwealth has proved every element of murder beyond a reasonable doubt, then you should find that Mr. Walsh is guilty. On the other hand, if you all agree that the Commonwealth did not prove one or more of the elements of murder beyond a reasonable doubt, then your verdict must be not guilty. Let me talk about your roles. Jurors, you have the most important role in this trial because you will decide who and what to believe and whether the Commonwealth has proved Mr. Walsh's guilt beyond a reasonable doubt. You must be completely fair and impartial and unbiased in your work as jurors. Do not let your emotions, any kind of prejudice, or your personal likes or dislikes influence you in any way. Consider the evidence calmly and carefully. Do not be influenced by the nature of the charge or the possible consequences of your verdict. And do not let your personal feelings about any person, criminal charge, or anything else influence your decision. All parties who come before the court stand as equals before the bar of justice. That a case brought in the name of the Commonwealth does not entitle the prosecutor to any special consideration. Your verdict must be based on the law as I have given it to you, and on the evidence and the facts as you find, and nothing else. By contrast, my job as the judge is to impose sentence if the defendant is found guilty. Therefore, you are not to consider the sentencing consequences of your verdict at all. That's not your responsibility. So please put any issues about sentencing out of your mind. Let me next talk about evaluating the evidence. You must decide this case based only on the evidence that was presented at trial. You may not decide this case based on anything else. Do not consider anything you have read, heard, or seen outside of this courtroom. Those things are not evidence, and you may not base your verdict on guesswork, speculation, or suspicion. Let me talk to the important topic of the defendant not testifying. As you know, Mr. Walsh did not testify in this case. You may not hold that against him. Mr. Walsh has an absolute right not to testify because, as I've explained, he is presumed to be innocent and does not need to do anything to convince you that he is innocent. It does not matter why Mr. Walsh did not testify. It's not relevant to what you must decide, which is whether the Commonwealth has proved, based on the evidence presented at trial, that Mr. Walsh is guilty beyond a reasonable doubt. The fact that Mr. Walsh did not testify is not evidence. You may not consider it or even discuss it in deciding this case. Let me next talk about witness credibility. During this trial, you've heard from a variety of witnesses. With reference to any and all witnesses who have testified before you, you have wide latitude. As a jury, you can believe every single word that a witness says on the witness stand, or you can disbelieve every single word that a witness says on the witness stand. You may decide to accept parts of a witness's testimony and to reject other parts of his or her testimony. That's for you and you alone to decide. If there are any conflicts in the testimony, it is your function to resolve that conflict and to determine where the truth lies. In evaluating the credibility of witnesses, you may use various tools. You may consider the ability, the opportunity, and the reliability of the witness to see or hear something in the past, and then remember and later testify about it before you in this courtroom. You may consider the conduct of the witness, his or her manner of testifying before you, any inconsistency you may have found in the witness's testimony, any interest the witness may have in the outcome of the proceedings, any bias or prejudice or hostility the witness may have demonstrated while testifying before you, the level of accuracy of the witnesses testifying before you, and the reliability of the testimony as it developed before you. These are some of the tools that you have at your disposal to resolve disputed issues of fact in this case. There's one more point about witnesses that I'd like to specifically address, and that's expert witnesses. The term refers to witnesses who have specialized training or experience in a particular field, generally in cases that are tried in our courts of both civil and criminal. Witnesses may testify to facts that are within their own personal knowledge. That is, things they've personally seen or heard or felt. However, in a variety of cases, this one included, issues arise that are beyond the experience of laypersons. And in those types of cases, we allow a person with specialized training or experience, we call them expert witnesses, to testify not only to the facts, but to their opinions, the reasons for his or her opinions on issues that are within the witness's field of expertise and are relevant and material to the case. Because a particular witness has specialized training and experience in a field, doesn't put that witness on any higher level than any other witness. And you are to treat the expert witnesses just like you would treat any other witness. In other words, as with the other witnesses, it's completely up to you to decide whether you accept the testimony of the expert witnesses, including the opinions that those witnesses gave. It's also entirely up to you to decide whether you accept the facts relied on by the expert and to decide what conclusions, if any, you draw from the expert's testimony. You are free to reject the testimony and opinion of such witness in whole or in part if you determine that the witness's opinion is not based on sufficient education and experience, or that the testimony of the witness was motivated by some bias or interest in the case. You must also, as has been explained, keep firmly in mind, jurors, that you alone decide the facts. If you conclude that an expert witness's opinion is not based on the facts as you find those facts to be, then you may reject the testimony and opinion of the expert in whole or in part. You must remember, jurors, that expert witnesses don't decide cases, juries do. In the last analysis, an expert witness is just like any other witness, in a sense that you alone make the judgment about how much credibility and weight give the expert's testimony and what conclusions you draw from that testimony. Let me next talk about graphic photographs. The Commonwealth has introduced certain photographs showing items taken from various trash bags retrieved from 300 Forest Street, Peabody, during the investigation of this case. You will have those photographs with you during your deliberations, as all the evidence will be with you during deliberations. Some of those photos, as you've seen, are not pleasant. Indeed, some may be described as graphic. I instruct you that your verdict must not in any way be influenced by the fact that these photographs may be unpleasant or graphic. The defendant is entitled to a verdict based solely on the evidence and not one based on pity or sympathy for the deceased, which might be occasioned by those photographs. Related to this, sometimes evidence is presented that produces in jurors an emotional response. For example, it is natural and understandable to feel sympathy and empathy when you hear or see testimony that suggests what might have occurred to Anna Walsh's body after her death. But as jurors who have taken an oath to follow the law, I instruct you that you must separate any emotional response or reaction on your part from the informational value and weight of the evidence. You must not be influenced in any way by the nature of some of the testimony and video evidence. You must find the facts in this case based only on the evidence. You can't find facts or base your decision, again, on sympathy, anger, passion, or prejudice, or pity for or against either side in this case. Rather, again, jurors, your verdict must be based solely on the evidence in this case and my instructions on the law. So what is evidence? I told you earlier that repeatedly that you must decide this case based only on the evidence presented at trial. The evidence consists of the testimony of the witnesses, as you recall it, the things that were marked as exhibits, and the stipulations, or I told you those agreements, of the parties, which I read into evidence. You will have the exhibits with you in the jury room. Things that were marked for identification aren't exhibits, so don't be looking for those, and because they're not exhibits, and you won't be able to consider them. Other things that are not evidence and you may not consider when deciding this case are as follows. The fact that the defendant had been indicted and charged with a crime, not evidence. Questions that the lawyer asked of a witness are not evidence. Only the answers given are evidence. For example, if a lawyer asked, wasn't it raining outside? And the witness answered no, or said, well, it was cloudy. The question is not evidence that it was raining. If a lawyer asked a question and I sustained an objection and therefore the witness didn't answer it, then neither the question nor the fact that the witness did not answer is evidence. If I struck or told you to disregard any part or all of an answer by a witness, then the part of the testimony that I struck, not evidence, you may not consider it. Anything that you may have seen or heard when the court wasn't in session isn't evidence. The opening statements and closing arguments of the lawyers are not evidence. And if your memory of the testimony differs from what the attorney said in their closing arguments, you should rely on your memory. Any notes that you've taken, they're not evidence, but you may use your notes to refresh your memory of the evidence. As you know, evidence can come in many forms. It can be testimony about what someone saw or heard or smelled or felt. It can be someone's opinion, and it can be an exhibit. Whether the evidence is direct or circumstantial, sometimes we call that indirect, the Commonwealth must prove the defendant's guilt beyond reasonable doubt from all of the evidence in the case. Some evidence proves a fact directly. For example, if a witness testifies that she saw and felt it raining outside before she came into the courthouse, then that's direct evidence it was raining. Some evidence proves a fact indirectly, circumstantially. For example, let's say a witness testifies that he saw someone come into the courthouse wearing a wet raincoat and shaking water off of an umbrella. That's indirect evidence.
That, if you believe it, might lead you to conclude that it was raining outside, even though the witness did not see, hear, or feel the rain. This kind of indirect evidence does not directly prove something is true, but it is evidence from which you could logically conclude that it is. We call this drawing an inference. We all draw inferences every day. We take some known information, we apply our intelligence and common sense, then we reach a conclusion. But inferences must be based on facts. They can't just be guesses that you make when you're not sure about something. Sometimes you can draw more than one inference. Also, you may draw an inference even if it is not necessary or inescapable, so long as it's reasonable and warranted by the evidence. You have to decide, jurors, which inferences are reasonable and decide which seems more reasonable to you. It makes no difference whether evidence is direct or indirect. Commonwealth may be able to prove a criminal charge with direct evidence, indirect or circumstantial evidence, or a combination of both. Let me next talk about credibility. An important part of your job as jurors is to decide who and what to believe. You may believe everything a witness says, part of it or none of it. Sometimes people do not tell the truth. You must decide whether a witness was being truthful or deliberately lying. If you conclude that a witness lied to you about something, then of course, you should not believe that part of the testimony. Sometimes people make an honest mistake. You must also decide whether a witness testified accurately or whether the witness may have gotten something wrong without meaning to do so. A witness may recall seeing or hearing something, but actually be mistaken. For example, the witness might not have paid close attention or might have misunderstood what was happening. Or a witness's memory of what happened could be incorrect. If you conclude that a witness tried to be truthful, but that some part of that person's testimony was inaccurate, then you should not consider the inaccurate portion. How do you decide whether you believe a particular statement by a particular witness? Well, ask yourself, did the testimony seem reasonable or probable? Did the witness have a good chance to observe what happened? How much attention did the witness pay? Did the witness's memory seem accurate? Was the witness's testimony consistent with other evidence, or instead contradicted by other evidence? How did the witness behave and answer questions while on the witness stand? Did the witness have any motive for testifying in a certain way, or have any other bias that may have influenced the witness's testimony? You should evaluate the testimony of a police officer or someone else who works for a law enforcement agency in the same way as you would evaluate anyone else's testimony. You must not automatically believe or automatically disbelieve a witness just because a person is a police officer. Moving next to the importance or significance of evidence. It's up to you, jurors, to decide how important each part of the evidence is, whether it's testimony by a witness or an exhibit, whether evidence is direct or indirect. You should give each piece of evidence whatever significance you think it deserves. You're not required to believe something simply because it appears in an exhibit. It's up to you to decide how important any exhibit is. You do not have to treat testimony by a witness as more or less significant than the exhibits. You may find that a witness's testimony is very important, or that an exhibit is more important. That is up to you. Next, I want to talk about the alleged victim's state of mind. You heard evidence of statements on a Walshe allegedly made to William Fasto, Jem Lutlu, and Alyssa Kirby. Those statements are admissible for the limited purpose of establishing Anna Walsh's state of mind, as may be relevant to the defendant's motive or intent to kill. Those statements cannot be considered as proof of the criminal acts charged or as proof that the defendant had a bad character, or a propensity to commit any criminal offense. Let me next talk about motive. First, motive is not an element of the offense of murder, and the Commonwealth is not required to prove or show motive. Evidence of motive can be relevant to the issue of intent. Second, an absence of evidence of motive may tend to raise a reasonable doubt. Third, even a total lack of evidence of motive would not necessarily raise a reasonable doubt as to the guilt of a defendant, so long as there is other evidence produced that is sufficient to prove the guilt beyond a reasonable doubt. Let me now move to the area of something called consciousness of guilt. Spoke earlier about inferences and the drawing of inferences from indirect or circumstantial evidence. At this point, I want to talk about a particular type of inference based on a legal doctrine called consciousness of guilt. In the course of the trial, there was some evidence suggesting that the defendant may have intentionally made certain false statements before his arrest, and that he may have taken steps to conceal Anna Walsh's body after her death. I want to stress to you that I'm not suggesting that he did so, or that you should find that he did so, but only pointing out that there was evidence to that effect. It's up to you to decide what evidence to accept or reject, and what facts to find from the evidence. I point to that evidence to illustrate the legal point involved. If you find from the evidence that the Commonwealth has proved that the defendant provided false information to the police and or took steps to conceal the body of Anna Walsh after her death, then you are permitted to consider whether such actions indicate feelings of guilt by the defendant, and whether in turn such feelings of guilt might tend to show actual guilt on the charge. You are not required to draw such inferences, and you should exercise great caution and do not do so unless they appear to be reasonable in light of all the circumstances in this case. You should always remember that there may be numerous reasons why an innocent person might do such things. Such conduct does not necessarily reflect feelings of guilt. Please also bear in mind that a person having feelings of guilt is not necessarily guilty in fact, or such feelings are sometimes found in innocent people. If you decide that such inferences are reasonable, it's up to you to say how much importance to give them. But remember that such evidence is never enough by itself to convict a person of a crime. You may not find a defendant guilty based upon such evidence alone, but you may consider it along with all of the other evidence in this case. Next, I want to speak to impeachment by the defendant's prior or subsequent bad acts. The only charge the defendant is now facing is the charge of murder. You have heard mention of other acts allegedly done by the defendant, namely, that he was charged in 2018 and sentenced in 2024 in a federal case involving art fraud, and or that he lied to the police, and or that he disposed of the body of Anna Walsh, and or that he lied to his federal probation officer. You may not take the defendant's prior or subsequent acts as a substitute for proof that he committed the crime charged, nor may you consider them as proof the defendant has a criminal personality or bad character. You may consider this evidence solely on the limited purpose of the motive, state of mind, intent, plan, or absence of mistake or accident on the part of the defendant. You may not consider this evidence for any other purpose. Specifically, you may not use it to conclude that if the defendant committed these other bad acts, that he must have also committed murder. It would be extremely unfair to consider this evidence for those purposes. Moving next to your notes. Many of you have taken notes during this trial. Your notes may help you remember the evidence, especially the testimony, but of course they're not an actual transcript or official recording of what was said. So use your notes only to help you remember what you saw and heard in the trial. Whether you took notes or you did not, you must rely on your own memory of what the witnesses told you. After the trial is over and you've returned your unanimous verdict, the court officer will collect your notes and I will order that they be destroyed. During the trial, the lawyers occasionally, as was appropriate, objected to questions posed by the witnesses. They may have asked to strike something or, in essence, erase something you saw or heard. When a lawyer believes that something would violate those rules of evidence we've talked about from the beginning, that's the only way they have to let me know. And so don't hold it any against the lawyers that they made such objections. It's part of their job. I want to next turn to fairness. Each of you has taken an oath and promised to be fair, and I'm sure you want to be fair, but that's not always easy. Part of being fair is being willing to examine your decision-making process to be sure that you base jurors only on the evidence and the law. One difficulty comes from our own built-in expectations and assumptions, and they exist even if we're not aware of them. We all have them simply because we're human beings. They affect our actions and decisions without us even realizing it. As a judge, I have the same problem as everyone else. So let me share a few strategies that I found to be useful. These strategies will help you make sure that you decide this case based, again, only on a careful examination of the evidence and on the legal rules that I'm teaching to you. First, slow down. Do not rush to a decision. Take time to consider all of the evidence. Quick decisions are more likely to reflect stereotypes or assumptions about people that we might not even be aware of. Second, as you start to draw conclusions, consider not only the evidence that supports your conclusions, but also think carefully about any evidence that undermines or weakens those conclusions. Third, as you think about the people involved in this case, ask yourself, would my decision be different if the people were different? For example, what if the people involved were from different social or economic groups, or different ages, genders, gender identities, or sexual orientation, or came from a different racial or ethnic background? Fourth, listen to each other. Other jurors may have different points of view. If so, they may help you make sure you're focusing on the facts. Of course, other jurors could be influenced by their own unstated assumptions. So don't hesitate to share your views. You should participate actively, particularly if you think other jurors are overlooking or undervaluing evidence that you think is important. When you explain your thoughts to your fellow jurors, you help everyone focus on the evidence. If you do these things, then you'll play your part in reaching a decision that's as fair as is humanly possible. And that's your obligation as jurors. Now I'm going to move to giving you some instructions about how to conduct your deliberations. Privacy. The first point you need to know is that you must keep your deliberations secret. You should not tell anyone outside of the courtroom, not even me, anything about your deliberations. For example, please do not tell me or anyone else the results of any votes that you may have taken before you all agree on a unanimous verdict. You must not tell anyone about how your discussions are going or what other jurors are saying. If you need to communicate with me before you reach a unanimous verdict, you should send me a written note and a form that you all agree on. The court officers have it. It must be signed by your foreperson, and I will discuss your note with the lawyers, and then I will either send you a response in writing, more likely, or bring you into the courtroom, less likely, and respond to you in person. If you do send me a note, do not mention any votes that you have taken or anything else about your deliberations. Do not talk about this case unless all of you are present and no one else is in the room. If one of you needs to leave, even for a moment, the rest of you should stop deliberating until that juror returns. That includes the bathroom breaks, because I know that's right inside your spot. If we break for the day without you reaching a unanimous verdict, you must not communicate with the other jurors about this case until the next day, only after we gather in the courtroom, and I ask you to resume your deliberations. As you work to decide this case and until I accept your verdict, you must not communicate with anyone else about the case except each other. And you must not do any kind of research about this case. You may not do so in any way, including with electronic devices, a cell phone or a tablet. This also will apply to the alternate jurors. We talked about those alternate jurors. The law permits only 12 jurors to participate in deciding a criminal case. There are 16 of you here. So in a few moments, our clerk is going to randomly select 4 of you to be what we call alternate jurors. The other 12 of you will work together to decide this case. We chose 16 of you originally in the case, just in case one or more of you got sick or needed or had some other unexpected emergency. If you are chosen as an alternate, your continuing service is still very important, and you must comply with all of the rules that I placed on you. The alternate jurors will stay in another room, and you can't have your own private deliberation. You can't discuss the case with each other or with anyone else for obvious reasons. If we lose a deliberating juror in the group of 12 because of some personal emergency or sickness, then I will send one of the alternates into the jury room. If this happens, the deliberating jury will have to restart its discussions from the beginning. One of you is going to serve as the foreperson of this jury, and we will discuss who that foreperson is going to be in a moment. Foreperson will make sure that each of you has the chance to speak and that the other jurors listen to you respectfully. But the foreperson's opinion about the case is no more important than the opinion of all of the other jurors. Once you agree on a verdict, the foreperson will fill out the verdict slip and will report your verdict in court. I want to next talk about making decisions as a group. When you work together as a jury, you will be making decisions as a group. This kind of decision-making is very valuable. Why do I say that? When a jury hears and sees evidence, each juror acts as a safeguard for the others. For example, someone else may recall evidence that you missed, and each of you will have insights that will help the other jurors make sense of the evidence and reach a verdict. No member of the jury is more or less qualified than any other juror to decide who and what to believe. You've all heard the same evidence, listened to the same witnesses, and looked at the same exhibits. And you have all taken the same oath, promising that you will, well and truly, try the issues between the Commonwealth and the defendant according to the evidence and the law. So, you are all equally qualified to reach a verdict. I have a few more suggestions that might help you work better together. First, you should discuss and analyze the evidence before you take any votes about a verdict. Voting first could keep you from discussing the issues and hearing other people's perspectives before making up your own mind. Second, I encourage you to discuss not only the evidence you think supports your view of the case, but also what evidence you think might lead you to make a different decision. Third, as jurors, and as the other jurors talk about the evidence that they found important, listen. In order for this process to work fairly, Each of you should hear every other juror's insights and ideas. Please be open to them, since they might influence your own thinking. Fourth, don't be shy. As in any group, some of you may feel more comfortable than others sharing your thoughts, but you must have the benefit of everyone's input to help you reach a just verdict. For example, you may be the only one that remembers a particular piece of evidence or has a particular point of view. The more points of view that you all hear, the more effective your deliberations will be. Fifth, don't be afraid to change your mind if the discussion persuades you that you should. But you should not accept a decision just because other jurors think it's the right one. In the end, you should vote based on your own assessment of the evidence, regardless of how other jurors have voted. Ultimately, jurors, each of you must decide this case for yourselves. One last pause to consult with the attorneys. So I talked to you about a four-person, and I talked to you about what we call reducing the jury. That is, reducing you down from 16 to 12. I'm appointing juror number 138 and seat number 6 as the four-person of this jury. Our clerk is now going to randomly select 4 of you from among all of the jurors except the four-person to serve as alternate jurors. So what's physically happening is juror number in seat number 6, juror number 138, numbers coming out of the, thank you, Madam Clerk.
Your Honor, numbers 1 through 16, with the exception of number 6 of this. Your Honor, our first alternate is juror in seat number 12.
Grab the notebook and just follow me.
Our next alternate is juror in seat number 5. Juror in seat 15. And our last alternate, Your Honor, is juror in seat number 11.
One last substantive thing that I want to go over with you jurors before I really get into the concluding remarks. And that is, I said to you earlier in this second part of the charge that I would go over the verdict slip. There is a verdict slip, and I know that you can't, unless you have stellar vision, you can't see it from where you are, but you can get the layout of it. I'll read it to you. The verdict slip reads, count 001 on or about January 1st, 2023. And it puts the charge, murder in the first degree with deliberate premeditation. That is the charge. We, the jury, find the defendant and there are three options. Not guilty, guilty as charged, murder in the first degree, guilty of murder in the second degree. And there's a place to sign it and date it. And again, the foreperson in pen, not pencil. This time, Madam Clerk, I'm going to ask you to swear in court officers.
Do you solemnly swear or affirm that you will take charge of this jury and keep them in some secluded places where they be? You shall not speak to them or suffer anyone else to speak to them except by order or would ask that they be so help you God.
I will.
So now the deliberating jurors, the 12 of you, are going to go instruct with private discussions. Have confidence in what you are about to do. By serving on this jury, you carry out a long and proud tradition of citizens of the Commonwealth of Massachusetts serving on jury trials and deciding criminal cases. If you are honest, thoughtful, and fair, you will be able to reach a fair and just verdict dictated by your logic, without bias, without prejudice or sympathy, and not prompted by any facts except those that you've heard here in the courtroom during this trial. All we expect from you jurors is that you decide this case with integrity and principle. And with that, I'll ask you and let you go back to the deliberation room to begin your work. Thank you very much.
Court, all rise, please. Jurors, take your notebooks with you and follow me.
So I will, as I said to you at the side of the bench, there are some small edits necessary to fact. You may be seated. There's some small edits that I'm going to make to the instruction, and I'll make those now, take the draft off, make sure the numbers are all right for the index that goes down with them. Anything else that the parties need to bring to my attention before I forget?
We received materials to secure those items, and we're going to work on
Can I
that.
see that? Are they in secured yet, or you're going to?
We're going to secure them. I haven't had the opportunity yet.
All right, let Madam Clerk know when that's done, because I do want to take a look at those before they go in. And of course, our court staff, as well, court officers, want to take a look at those to make sure that they're comfortable with what's going on.
And we thought we'd cut up pieces of parchment paper for the jurors if they need to examine anything that they can place on their table.
You have a roll, they can do it themselves.
We have a roll. We can give them scissors if you want.
Well.
I think that's why I put that out there.
All right.
Thank you.
I think you're pretty familiar that I have a 10-minute rule, which means at all times, Madam Clerk, to be holding you to be able to return to the court within 10 minutes. All right. I won't take it further between the hours of 1 and 2 on any day with opportunity to attend to your other work.
Thank you, Ron.
All rise.
Well, there you have it, everyone. That was really long and tedious, but I thought that they were extremely good and thorough, fair to both sides in terms of the instruction. I think it was very important, the adding of the language regarding murder too. I think everybody is, if for some reason it is not murder one, which would be punishable by LWOP, that a judge can order sentences to be concurrent or consecutive. Concurrent meaning on top of one another. So in other words, say he got, 5 for lying to the police and 5 for dismembering the body and 20. Those could be served consecutive for 30 years. And again, I think everybody knows this, but if you are not, for any reason, if you are not serving in federal, and even if you are serving in federal, you can never serve the entirety of one's career, or one sentence. So say you get 10 years, in a lot of states you serve about 50%. In some you can serve up to 85. Federal, it's 85, and that's assuming that there are
During those conversations and your observations, Anna told you that Brian wasn't the jealous type.
That's correct.
Sorry, everyone.
And at some point, while Anna was working for you, she confessed that she had a crush on you.
She said that.
in some states.
Yeah, maybe.
I think you've already kind of said it, but Mr. Walsh was never jealous of your relationship with Anna.
I don't believe so.
Old Jim Mutlu, he was the boss of Anna and friend. They worked together for years before she got this great new job. And he was there with Brian and Anna the last day anybody saw her alive. That was New Year's Eve, and they celebrated the end of the year. You can see the verdict clock is now on our screen. The jury has just been given the case 3 minutes ago, so they're just getting settled in the deliberation room. We're still picking up the rest of the closing arguments right now from the Commonwealth. Anna's husband, Ryan, of course, is facing first-degree murder. If he is found guilty, he'll spend the rest of his life in prison. He's hoping beyond hope that somehow this jury believes the story that he just found his wife dead and didn't know what to do, and decided that his best course of action was not to tell anybody, not to call 911, not to try to revive her, but to chop her up and get rid of her body. Let's go in and watch the end of the Commonwealth's closing argument.
Not there. He went to CVS to buy hydrogen peroxide, and then he went to Stop and Shop to buy ammonia. No wonder the house was so clean. And on Monday, January 2nd, he went to Home Goods for rugs and candles. And then he went to Home Depot, where he had bought buckets with lids this time, baking soda, and a hatchet. And at some point that day, he got a call from his probation officer, and he lied, and he said that he was picking up his children. He was able to calmly speak with her. No panic. He had everything now that he needed to dismember the woman that he supposedly loved. And he started to take her body and to throw it into dumpsters, because he had to cover up the crime to get rid of the evidence of the murder. This was not a man in crisis. This was a man who on January 4th went to TJ Maxx to buy pants with the store exchange card. He was humble. But Alyssa Kirby texted him on January 4th asking about Anna, and so he called Tishman's Fire a few minutes later and started to pretend to look for her. He called Will Fastel, but he didn't leave a message. He called back later, and then he calmly left a voicemail. No panic. The defendant knew where Anna was. The defendant even texted Anna's sister in Canada and said that she was missing. He was methodical. Look at the text messages. And at 4:30 p.m. on January 4th, the defendant went to Lowe's to buy a trash can. Comfortable. Not confident. police were coming to the house and talked about Anna. And the defendant had the house ready. The police think his wife is in DC. He had his phone records ready, and he sent text messages to Anna, even though he knew she would never see him. Despite everything that he had done, on January 2nd, the defendant wrote a text message to Anna. I still love you. Ha ha. Miss June. The defendant prevented anyone from ever finding Anna's body in no autopsy. Dr. Atkinson told you that the medical examiner can't do an autopsy without a body, and all that remains of Anna are 2 hairs, some blood, and a few things that belong to her. A part of a necklace she often wore, her hunter boots, a black jacket, a purse, her COVID card, and a few other items in the dumpster in his mother's apartment complex. The defendant searched his MacBook for a murder conviction without a body. Please do not allow the defendant's self-serving act of dismembering and disposing of Anna's body to let him get away with this murder. At the start of this trial, we asked you to use your common sense. When you do that, when you analyze the evidence as you deliberate and continue to use your common sense, you will see that the evidence shows there is only one verdict. Find the defendant is guilty of the premeditated first-degree murder of Anna Walshe. Thank you.
All right, that's the end of the Commonwealth's closing argument. It was subdued, especially when you compare it to the defense close from Larry Tipton, who was very passionate. And what he was saying, maybe people didn't agree with, but how he said it, I mean, I think he grabbed the attention definitely of the jury. They have the case, 8 minutes and counting. Josh Schiffer, Philip Dubé still with us. Josh, the subdued, she didn't need to, you said it last time, she really didn't need to do anything more than she did. Like, just be calm and read her paper and get those people back into the room.
The sale was already really made during the trial. The state got up, presented a whole bunch of evidence. The defense said, "Hey, we're gonna answer this," and we all watched. There wasn't a lot of answer. So then, in summation, the state has its opportunity to just say, "Hey, y'all, look at what this is." And Ted, you referenced earlier, kind of the wink and just go do your. That's really what I think the state almost could have done more of. Is, "Hey, y'all, you know what we're here to do. You haven't heard any reason not to follow the request of the state to do your job as jurors and issue a conviction, because there's not any evidence that contradicts our allegations."
I loved, Philip, the one thing the prosecutor said was, you look at those internet searches for what they are and read them, and those are powerful. But then the searches that he didn't make, like, how do people just drop dead? And has a wife ever just laid there dead? And what do I do? None of that. He's not curious in terms of how she died at all. And Mr. Google wasn't interested there. Your overall thoughts on this case and where it's going to end up?
Well, I thought the defense was going to put on more or some evidence to explain how she could have died. Because remember, during the defense cross-examination of a couple of the witnesses, they were alluding to her dying of Legionnaire's disease. And I thought, oh, goody, we're going to get a real natural cause of death here. They're going to put on somebody who worked on their HVAC heating and air conditioning system and found a breeding ground of Legionella bacteria that could be deadly in the workplace. Nothing. Instead, all they did was just sort of float the idea as a kernel of doubt, which is okay, I understand that. But to seasoned defense lawyers and to seasoned courties, it looks like you couldn't find anybody to come on and testify to that fact. The one criticism I do have of her, I just think that her delivery, given all the salient facts that she has pointing toward guilt, was just a little too sing-songy. And I mean, if we're really honest, I mean, even as Josh, you could have given this case to a first-year DA. You don't even, I mean, this is a classic type case you'd want to cherry pick because you know it's a dead bang winner. But sometimes, even with the winning cases, if you don't have the right delivery, you put your jury to sleep and then they listen more to the defense. So I don't think this is going to be a straight up not guilty, but it would not surprise me in the least if this deadlocks.
Interesting. And that would be a massive loss, Josh. There would be some memos thrown around in the DA's office.
I would say that, I unfortunately kind of agree with Phil that there is that outstanding chance because the state, as great a job as they did, could have done better, could have wrapped it up smoother, cleaner, tighter. I understand that they let him plead to the lesser charges in order to try to steal some thunder. There was some big-time strategery involved in what facts were going to come out. But you just saw the state talk about the fact that he was on monitoring. It doesn't take too much to get into the fact that the jury's going to know about some of the prior issues that were causing marital stress, which is the motive that since they don't have the details, the fantasy minds of jurors can go all over the place. And without telling them exactly what's up, they could really extrapolate into some fantastic motivations. State played that very, very well because the jury knows that there were problems. Without an expert coming for the defense to testify, yes, the HVAC, breeding, Legionnaires, like Philip's saying, that's how you defend this case.
Or even someone that says people die, or someone that says, this phenomenon that sounds ludicrous does happen. Is it rare? Absolutely, yes.
Yeah, you needed an expert.
Yeah, absolutely. Yes. Is this case, Philip, almost freeing as a public defender in LA? You have been up against some cases over your time that were just absolute. You were the absolute underdog. Does it free you as a litigator, like where we saw with Tipton? It's like, all right, we're going to lose, but I'm going to go all in. And because it feels as though the Commonwealth is a little tight, like they're the favorite in a football game, and they just don't want to lose to this bad team. And Tipton, on the other hand, is just letting it fly.
Well, I think a lot of it has to do with the delivery, because on paper, cases for the prosecution can really seem to be airtight, impenetrable, but it's all in the presentation. I mean, the whole thing could really fall apart in front of a jury. And even when you do present it all, if you do not have the right manner in your presentation, then it can just sort of collapse and crumble right in front of a jury. And I've seen that happen. And not just at trials, I've seen it at preliminary hearings where they put a baby DA on the case and they just screw it up. They don't know how to mark exhibits. They don't know how to introduce evidence, and they don't know how to argue it. So I think a lot of it really just depends on the caliber and the quality of the attorney trying and defending the case. That's just my opinion. And one other thought, and that is, I truly believe that there was a reason why the body was chopped up in the manner in which it was. I think in order to normalize what had happened, the body had to go into sort of like hefty bags, so it wasn't looking like he was lugging something large, like a Foot Locker or something even bigger, where you could automatically assume that somebody is carrying a body out of the house because nobody has seen or heard from Anna in all this time. But when you do it in little bags, in small, little hefty containers, it sort of normalizes the criminal aspect of trying to get the job done. So I think that's why it was done in that manner.
Josh, there's a very good chance that they get back in that jury room, they all look at each other and say, do you want to eat lunch first or just head back and deliver the news?
And really, for Mr. Tipton, just to touch on something Phil was talking about, fail hard. That's what my lawyer tells me. If you know that you're facing the uphill, you don't want to incrementally attack and take a tedious, trepidatious approach. No, swing hard, fail hard, go down swinging. That's what a good lawyer does, and I really appreciate Mr. Tipton really swinging like that.
Yeah. All right, we'll get a break at 16 minutes and counting. The jury has had this case just getting underway, picking a 4-person, and then who knows how long it's going to take, but we'll be here waiting. There's the live look inside that Dedham, Massachusetts courthouse. We're used to the Karen Reed fan. Well, this is the Brian Walshe clock. It's ticking.
The disappearance of mother Anna Walshe.
Her husband now charged with her murder.
All eyes on this accused killer.
Mr. Walshe was suspecting his wife of having an affair.
A massive trail of evidence.
This incredible timeline of Google searches.
It shows everything that was in his mind.
He searched how long before a body starts to smell.
The disappearance of Anna Walshe murder trial. Live coverage today on Court TV.
So that was interesting. We got to hear a little bit from Josh and from Philip. As many of you know, they're certainly friends of Break the Case. I have them on often. I always get such a kick out of Josh. I would really like to see him in practice. I think he'd be very interesting. He's so flamboyant. And then, of course, Philip is really focuses and hones in on facts. I could see Philip and I were definitely, in line with how we evaluated the prosecution and the delivery. I don't think this is going to be hung. Philip mentioned that. I don't think that that's going to be the case here. I haven't lost complete hope in Massachusetts juries, by the way. I wanted to ask, did anybody see, I actually did a tweet on it this morning while we have a little time here. Did anyone see this is in Dedham, so where this is occurring, at a Catholic church there, where they had the baby Jesus in the nativity scene gone, and then they say something to the extent of, ICE was here, meaning stole baby Jesus. I guess much to the chagrin of the, head of the Catholic Church, but the local Catholic Church did that. I'm not trying to bring up politics here, but when I first saw this was in Dedham, Massachusetts, I was thinking, well, of course it's in Dedham, Massachusetts. I've seen things happen there and in that courtroom during that retrial that I thought I'd never see happen. And then I just thought that was interesting. Did anybody else see what I'm speaking of? I don't know how delayed this is, but nevertheless, I didn't want to sidetrack too much. I just thought that was very interesting that happened in Dedham. And I thought it was really atrocious to draw such a comparison. Can anybody hear me, by the way? In chat? Oh, okay. Okay, Hero says yes. I wasn't sure because I'm not in charge of this feed, and since Court TV went silent, I thought that the whole feed might have gone silent. But anyway, yeah, I just wanted to touch on that I thought was interesting. It seems like we're all kind of on the same sheet of paper, that we think this will be a pretty quick verdict. I'm looking at all the names here in chat. I've got my glasses on, so I see you all. And I know almost everybody has been here for such a huge majority of this trial. I really think that the reason this just took everybody really was such an attention getter, considering how many trials go on all the time of just horrendous murders that take place. I think it was the fact, the whole...
Welcome back to Court TV Live. The jury in Dedham, Massachusetts has the case against Brian Walshe. His fate is in that group of 12's hands. They've been at it now just about 20 minutes. Walshe, of course, is accused of killing his 39-year-old wife, Anna, with whom he had 3 kids. Before jury selection began last month, he came in and admitted to the lesser charges in this case. He said, yes, I dismembered her body. I disposed of her remains in dumpsters. He maintained his innocence, though, in terms of murder. He says that he woke up, or he found her asleep. When he went to bed, he nudged her, and nothing happened. And then he nudged her a couple more times and realized she was dead. Somehow, some way, she was just dead. And then his story, which we heard through his attorney, is that he freaked out, didn't know what to do, and he thought the best course of action was not to call anybody, not to try to revive her, not to investigate why she died, but to chop her up and get rid of her body. It's ludicrous. It seems ludicrous, but we've been watching it for 8 days now, and his attorney's been all in, and you wonder, did a juror or 2 take the bait? Josh Schiffer, Philip DeBay, both with us. Here we are, 20 minutes in, and we're of course, if we get a question or a verdict, we'll head right back to Dedham. You first, Philip, I want to talk about a couple of the key witnesses in this case, and one of them was this Jim guy. He was the former boss. He was there on the New Year's Eve. He was there during this celebration, and he said that there were a couple things that came out of his testimony. One was that he said, Brian Walshe is not a jealous guy because she had a crush on me, and he knew that she had a crush on the guy that she was actually having an affair with. And he was not a jealous person. He was okay with it. The other thing he talked about, though, was that he was told by Anna that the marriage was having trouble. Let's listen to Jim on the stand and then talk about it.
What did she tell you about her life at the time?
That what I got from it was that there were some issues, marital issues included. And and that I told her, I said, I don't want you to be too strong. Have you considered therapy? And she said yes.
Okay. What is your memory of what she said as far as marital issues? And not your feeling, but what you remember the conversation to be, sir.
Sure. Part of it was that she was going back and forth from DC, which was taking a toll on her. And the fact that that Brian had not been able to leave Massachusetts, so the children were here. And that was a huge burden on her psyche.
Philip, how effective was this witness for the Commonwealth?
To be honest with you, I thought it actually helped the defense because she's not saying stuff like, he's just too boisterous. I don't like the way he talks to me. I don't like the way he treats the children. He talks down to me. He's got a drug problem. He's spending all of our money. Instead, it's basically a forlorn spouse living in sort of multi-employment states. You're bobbing back and forth from Massachusetts to DC. He doesn't want to move to DC. Well, that's not saying that there's an inherent character flaw or some type of personality in Brian Walshe. It's just saying that she's lonely and she wishes that they could be together. It would be one thing if she would have said, I want out. I want a divorce. I don't love him anymore. He doesn't love me. We've grown apart. Love is on the rocks. He doesn't bring me flowers anymore, kind of thing. But we're not hearing it. And this is a classic situation when you have like bi-coastal relationships or couples and other partners who are just living apart. So I don't really think that he really moved the needle in favor of the Commonwealth. Okay. And there was one other note. I took issue, and I don't know if Josh agrees, with this whole line of testimony even coming in. Because if you really think about it, I think the prosecution was offering it to prove the state of mind of Anna. Well, it's classic hearsay in that regard for 2 reasons. Number one, Anna's state of mind is not even relevant. If anything, one of the elements of murder is malice aforethought, meaning an intent to kill on the part of Brian Walshe. So I don't even know how Anna Walsh's state of mind is even relevant. But even beyond that, it is classic hearsay because it's testimonial in nature. And I don't think it's strong enough to get around the hearsay rules to show some type of motive, because here the motive is not even present. Again, it's not as if there were discussions about parting because of money or other problems.
Right. Josh, we should note that Brian couldn't go to D.C. because he had the federal case against him, and he was locked in Massachusetts. Your thoughts, Josh?
So Jem was one of my top 5 witnesses of 2025. I thought that he was absolutely fantastic. Besides the fact that I just think he's an interesting fellow that is the kind of person I like to hang out with, I think his honesty and authenticity was rock solid. I don't think really wanted to be there. And I believe the Commonwealth called him in order to prevent the defense from calling him. And they stole some of the defense's thunder because just like Philip's talking about, the testimony was very beneficial for the defense when it comes to really filling out a bunch of things that the state didn't want to be emphasized. And that's because Jem was honest. And notice when you listen to a witness like that answering the questions, he takes his time, he's thoughtful, he's fair, he doesn't want to say the wrong thing, and he wants to be really accurate. That is the best kind of witness. And he's just engaging, and you want to hear from him. The Commonwealth did get a couple solid points in, but I'm kind of with Philip where the defense made some of its best intrusions into the state's theory through Jem.
Yeah. And, he kind of looks like Sean Connery, so there's no...
Oh, God, love it.
It was great. I agree with you. He was interesting. You just watched him and listened to his mannerisms. The whole thing was great. Let's get a break. We'll have more. We're waiting for anything out of that courtroom. Plus, University of Michigan's head coach. That's next.
Wait a minute. Is he reading my feed? Our feed over here about Sean Connery? I guess I stated something pretty obvious, but that was so funny when he came back and called him Sean Connery, and we're just writing about how he's Sean Connery. Oh my gosh. Anyway, I thought that was funny, just the timing of it all. But anyway, I find it interesting that a lot of what we are saying and the notes that you all are saying, your reflections is a lot of what this panel is saying. So it's kind of interesting. As far as the federal time, recall that he was sentenced to about 3 years federal time for his art fraud shenanigans. The Andy Warhol selling a painting that he tried to say was an Andy Warhol and it wasn't. And so anyway, he's going to have to serve that first. He'll finish out that federal time and then he will serve the prison time. He's going to have prison time no matter what for the charges he pled guilty to. We just don't know whether he's going to get, LWOP, life without the possibility of parole. I think anybody who thinks he did this murder thinks he should get LWOP. But he should serve out the federal time first, and then he'll go back and serve his sentence in the other prison system, which would probably be likely worse. I have to say, I haven't been in Massachusetts penitentiary that he would go to, but typically the state penitentiaries are in far worse stead, and certainly for a fraud, type conviction, he's not in some maximum security federal lockup. I need to look and see where he is, but typically that would be in such a low, soft type prison environment anyway. It's going to be much worse when he has to serve his state time. Right. It was, Maui or Maureen Walshe, you're correct. It was 36 months, I believe. And remember, he will get, unless he does something wrong, they serve about 85% in the federal system. We were talking about this earlier. But in many systems, you don't serve that at all. Many serve about 50%, some a little bit more than that. And Massachusetts is actually one of the lenient. It can be 1/3 up to 2/3 of your sentence. A lot of it depends on how you act when you're behind bars. Do you get in trouble for anything, for having any sort of contraband, talking on a phone, getting in a fight, doing anything wrong by the rules? If you do, you can rest assured that you're going to serve more of your sentence. But a lot of people don't really know that. And this is why oftentimes, especially, I'll just go back to my experience working gangs. When I worked gangs, part of the reason why we formed a task force, which the task force basically was myself embedded in the Fort Worth gang unit with the detectives, and then also worked on the streets with the enforcement guys. I felt that was really important to get a true feel. But the reason we wanted to take almost every case we could, that certainly where there was money and drugs or murders, anything like that, obviously the more violent offenses, we wanted to take them federally because they got so much more time federally than they ever did in
Welcome back to Court TV Live. Busy Friday here. They always are. And verdicts always seem to come on Fridays as well. We're in verdict watching the case against Brian Walshe. Here's a look at all the cases that we're keeping our eye on today. In Massachusetts, the jury's been added for just about a half an hour. The case against Brian Walshe will take you into that courtroom as soon as we hear a peep. If there's a verdict or a question, we're there. In Ohio, it's day 3 of testimony for a man accused of drowning his estranged wife in a car nearly 25 years ago. And then in Michigan, this is where we're going to start the hour. Former University of Michigan head coach Sharon Moore expected in court this hour for an initial court appearance for an alleged assault earlier this week. And this has taken the headlines. Boy, oh boy, this guy had it all. Sharon Moore, he was fired as Michigan's head coach earlier this week for what the school is calling an inappropriate relationship with a staff member. Hours after he was fired, the married father of 3 was arrested and taken into police custody. Newly released dispatcher audio details the investigation into the alleged assault involving Moore. Take a listen.
Subject just called the caller, told her there's a mail notification that the house attacking her. The state's been stalking her for months. They call S1's wife in Ann Arbor saying that the subject is suicidal, losing his job today.
According to wife and S1's mother, he is at an unknown parking lot somewhere. We're attempting to have wife contact him.
The Associated Press is reporting that the charging documents have been filed. 3 potential felonies, home invasion. They're all home invasion and stalking related. And those dispatchers were heard saying that the subject, Sharon Moore, was suicidal, that he lost his job today. His wife, because he was, this guy's married, he's got 3 kids. He was at one point with his wife. She was so concerned because he left apparently with some knives that he was suicidal. She called authorities. This was a massive collapse. This is a guy that was getting ready to coach the Michigan Wolverines in a bowl game coming up. He had just had a press conference the day before, and then he lost his job, and then he presumably lost his family because it came out that he was having this affair. And now, at least for now, he lost his freedom for a night in jail because he is being charged with stalking and home invasion. Let's bring in, we're waiting for this hearing to get underway. It's an initial court appearance. Will be likely arraigned. There are cameras there, and our team is there. So we're going to go into that Michigan courtroom as soon as they get underway. We have the feed up, so as soon as we go, we'll head there. Philip Dubé is with us. He's a former public defender for Los Angeles County. Talk about a fall from grace. This is spiraling at just over a very short amount of time. Talk about these potential charges that he is facing in terms of seriousness and what kind of situation he's in.
Well, I'm not buying the home invasion aspect of it, Ted, and here's why. Typically, we associate home invasion with basically a form of residential robbery. And robbery really means is that you're taking property from somebody else by force or threat of force, as opposed to just barging in, wanting to have a discussion. If you're barging in to want to hit somebody, who knows, maybe even stab them or engage in some type of assaultive conduct, that's a form of burglary. entering a home to either steal or to commit a felony is the textbook definition of residential burglary. Now, given that, it still doesn't give him a pass to go over there and do that. I mean, if anything, he's supposed to set an example. But given the relationship that he had with this young staffer, he probably figured he could just go over there and throw his weight and his might around, and she would just kiss the ring to keep her job. Well, you know, she did this to the wrong person, and obviously her family was there and called the cops. So it's not looking good for him, and he's going down.
Okay, the judge is just taking the bench here, and I believe we have audio, so let's listen in.
Send that to Paul. Thank you. We are now calling case number 25F12175. This is the people of the state of Michigan versus Sharon Banfield Moore. Mr. Simon. Appearances.
Thank you, Your Honor. Good afternoon. Katie Rizmersky, First Assistant Prosecutor for the Special Victims Unit for the people.
And Your Honor, Joe Simon on behalf of Mr. Moore.
That's the charges, sir.
We waive formal reading of the complaint. Your Honor, stand you to the charges.
Formal reading having been waived, plea of guilty will be entered on your client's behalf. Simon, make your bond argument now or reserve.
Your Honor, I think the people want to make a presentation, and I'll go after that, if that's okay.
All right, Mr. Wisniewski.
Your Honor, thank you very much. I appreciate that. Mr. Simon. And thank you for the opportunity to be heard. As the court is well aware, this is not a series of offenses in Michigan that allow you to deny bond. We're certainly not asking for that. This is a felony of home invasion 3rd degree, misdemeanor stalking, and misdemeanor entry without permission. Your Honor, we are asking for a $25,000 cash or surety bond in light of the fact that we cannot ask for you to deny bond. I get that he is a man of means, and so this is a bit of a nominal monetary ask, but quite frankly, it would be an ask that I would make for any defendant charged with these offenses before you. So what strikes me as perhaps more important in this scenario are conditions that I would like to ask for. Because of course, as you know, Your Honor, you're tasked with trying to make sure that he reappears, but also the safety of the public and this victim in particular. So Judge, in addition to an ask for a $25,000 cash or surety, we're asking, should he post that, should you impose that? We are asking that you order that he undergo a mental health evaluation. We are asking that you order him to submit to a GPS tether and that there be a no-go to this victim's residence or place of employment. Ask that you order that there be no contact with her whatsoever in any means, any fashion, direct or indirect, that there be no stalking behavior of any kind, that he be ordered to surrender any and all weapons, further that he be ordered to surrender his passport. Judge, the reason, Your Honor, the reason we make those requests is in light of the factual scenario that gives rise to these charges. My best understanding from a thorough review of the police report and as much body-worn camera as I've had an opportunity to review is that I understand that our victim broke up, they had an intimate relationship for a number of years, defendant and victim. That our victim broke up with this defendant on Monday morning early, that there continued to be defendant making numerous phone calls and sending numerous texts from that time moving forward that she did not answer, did not respond to, and did not want. That eventually she presented herself to the University of Michigan, cooperated in some form of investigation there. As we all now know, defendant was at some point on Wednesday afternoon fired from his employment. He then, at some point soon thereafter, came to her apartment in the as alleged in the complaint, barged his way into that apartment, immediately then proceeded to a kitchen drawer, grabbed several butter knives and a pair of kitchen scissors, and began to threaten his own life. I'm going to kill myself. I'm going to make you watch. My blood is on your hands. You ruined my life. And a series of very, very threatening, intimidating, terrifying, quite frankly, statements and behaviors there in that apartment. It was only then, Your Honor, when the victim, she called her attorney and then at some point indicated she was going to call the police, and then he left. And so, Your Honor, while I understand that there isn't evidence to suggest that he directly threatened the victim with any of those implements that I've indicated. The totality of the behavior is highly threatening and highly intimidating. She was terrorized. And in light of the totality of all of those circumstances, we consider the defendant to be a risk to public safety, a risk to this victim, and it is for those reasons that we are asking for those specific conditions. I'm more than happy to answer any other questions that the court may have or give you further information. I appreciate the opportunity. Thank you, Judge.
The assignment is the bond.
Your Honor, let me start at the end where people end. In terms of risk to public safety, my client's 39 years old with zero prior criminal history, zero prior contact with the criminal justice system in any fashion. The threats to public safety argument by these charges, maybe that's the point, but there's no evidence to suggest that he's a threat to public safety. The next thing is that the people referenced the court rule that I want to come back to, that you can't deny bond in a situation like this. And they referenced something else that I want to come back to, which is the fact that they reviewed thoroughly the police. And they referenced something else that I want to come back to, which is the fact that they reviewed thoroughly the police report and they reviewed thoroughly the body cam. I've had none of that opportunity. And that's too early for that in the proceedings. So when people come in and make factual representations, although I trust Ms. Rizmirski very much as an officer of the court, I have no ability to respond to those factual representations. So here's what I'm going to ask the court. The monetary bond component, the two considerations by court rule are my client will appear. Let me speak to that. He's got a home here. His family is here. He's got ties to our community. He's retained a local counsel here. The second thing is that my client is not otherwise a danger to the public or danger to the complainant. There are other, that is why monetary components are requested, but there are other measures to address them. For example, the request for a GPS tether, that was an expected request. My client will gladly comply with that request. The second thing is my client having no contact. Certainly, we have no objection to that order, and my client would be at his own peril if he were to violate that. His bond would be summarily revoked. In terms of surrendering the transport or passport, Your Honor, there's no really indication that he is a flight risk. My client has those established ties that I talked about. But in addition to that, Your Honor, he would have an order from the court, like everyone else does, that there would be no leaving the state, let alone the country, without permission of the court, and he would certainly abide by that. Your Honor, with respect to the request for a mental health evaluation, I will represent a few things that are my understanding, again, without being privileged to have reviewed discovery yet. My understanding is that following his arrest, my client was taken to the St. Joseph Mercy Health System for an evaluation, a mental health evaluation. My understanding is following that evaluation, he was not turned over for a commitment, but instead turned back over to law enforcement for lodging. That's where he's been in Washington County Jail since. I can also tell the court that the community mental health department saw my client yesterday for an evaluation as well without any further recommendation. If you make that a condition of bond, I can tell the court that he goes to a mental health evaluation. He will absolutely comply and follow any aftercare recommendation. Lastly, Your Honor, with respect to the bond amount. I forgot to tell you about weapons. He has no weapons, but he'll surrender. If you order that he surrender any weapons that he doesn't have, he'll be glad to comply with that condition. With respect to the bond amount, Your Honor, in a case like this, with charges like this, in a normal circumstance, we'd be requesting a personal recognizance bond and frankly expecting the court to order it. We all know this is not our ordinary circumstance. It's not an insignificant amount of money to anyone. And I ask that the court set the bond amount to the principles, not of my client's bank account, but to the principles of the charges and to the principles of the court rule. Therefore, I'm requesting that if the court orders a monetary component at all, that it be with a $25,000 10% privilege. And also, Your Honor, if my client is to order to a GPS tether, things have to happen pretty significantly to try to get that in place in time for what we hope to be his release today. Thank you.
Mr. Moore, could you state your name, please?
Jerome Moore.
Sir, you are not to use alcohol, marijuana, or any other controlled substance that is not prescribed to you. You are not to possess or purchase a firearm or any other dangerous weapon. You are not to engage in criminal conduct of any kind whatsoever. You may not leave the state of Michigan without permission of the court. Prior to your release, you will be placed on a GPS tether. You will not be released before that GPS tether is placed upon you. You must continue all mental health treatment as a condition of your bond. The named victim in this case will not be placed on the record. You may not have contact with that individual. That means no calling, no writing, no video chatting, no texting, no emailing, or any other form of contact the human mind can possibly fathom. No one in the world thinks that this person is going to reach out to you. Should they do so, and again, no one thinks that they're going to, you may not reply in any form or fashion. The named victim's address will not be placed on the record, but you may not go to that location for any reason whatsoever. Are we understood on the no contact and no go to, sir?
Yes, Your Honor.
If you have any questions about that, you have a good attorney, simply ask them. You understand?
Yes, Your Honor.
Bond will be set in the amount of $25,000 cash surety, as requested by the prosecution's office. This court does not determine innocence or guilt. This court determines flight risk and community safety. The court finds with these conditions in place, it has been met. Mr. Simon, we are setting probable cause conference at this time for January 8th due to the holidays and scheduling. Is that a good court date for you?
Your Honor, my client will waive his right to have that next court appearance within 14 days. I've discussed that with him. I also tried to coordinate calendars with Ms. Wisniewski. In support of that, I think we're both available on January 22nd, if the court would order that. And I'll add one more thing for the record in support of that. I understand there is continuing investigation. So in addition to the discovery I don't yet have, there may be even more. So
it will be January 26th, 2020.
22nd, 15, 22nd,
22nd, Thursday.
January 22nd, then. January 22nd, 2026, 9 a.m., 14A1 District Court, Courtroom C. That will be in person. Sir, do not violate these bond conditions. Follow all orders of the court. Stay in contact with your lawyer. That concludes this hearing.
Thank you very much.
Okay, hearing is over. We'll get a break. We'll talk about what we just watched and what's happened, what will happen next to the former head coach of the University of Michigan, now in a jumpsuit appearing via WebEx from a jail. Plus, Walshe, the jury, almost up to an hour. Stay with us.
The disappearance of Anna Walshe.
Her husband now charged with her murder. All eyes on this accused killer.
The disappearance of Anna Walshe murder trial. Live coverage today on Court TV. Tonight on Closing Arguments, Brian Walsh's fate now rests in the hands of 12 jurors. We're live with every development as deliberations get underway. Closing Arguments with Vinny Politan tonight at 8/7 Central, only on Court TV.
But anyway, I just found that very interesting because typically the whole reason you waive that is you don't want to get it out into public, but now it's out into public. And the defense attorney was very kind about just saying, hey, listen, I don't have any discovery. I can't really discuss what you've said. Not that I think that you're lying as a court officer, but it was just interesting. I've never really seen that. Typically, when you waive the reading of whatever, whether it's an indictment or whether it's the complaint, everything is waived because it helps the defense. They don't want that out there. And the prosecution kind of snuck that in. So I thought that was a little sneaky by the prosecution. I'm surprised the judge didn't say anything. But anyway, I think everybody's pretty much at lunch, so I will head out as well, and we're on Verdict Watch. Thanks again, everyone, for being here, and for the mods for being here throughout this whole trial. Oh my gosh, I said I was leaving, but I always look back up through chat because I find your comments always so interesting. And I'm sure nobody's even here to listen to this probably. But if you're here, Kelly, that's so funny. This whole sourdough bread craze. Are you doing it? I wonder because you want to be gluten-free, or is there another reason? And I tell you, everybody is doing the sourdough bread. Now I have to say, I love sourdough bread, and gluten doesn't particularly agree with me, although I've never been tested one way or the other for celiac. I just feel so good when I don't eat gluten, but boy, do I love sourdough bread. So very cool that some of you are interested in it, it seems. While we're on this break, I just had to comment about that.
Welcome back to Court TV Live. We just watched the initial appearance for the former head coach of the University of Michigan. Just earlier this week, he had a press conference talking about how his team was ready for their bowl appearance coming up New Year's Day. And now Sherrone Moore is finding himself in the criminal justice system, facing multiple charges after an incident that took place at a home. And according to the prosecution, it was the home of a person that he had an intimate relationship for years. And it was she had recently broken it off. And he apparently didn't want that to happen. She went to the University of Michigan. He lost his job. And now here we are. There's his lawyer, who we just watched arguing in court, had a few things to say outside of the courthouse. Let's listen.
Everything to
Sharon Moore will be posting bond today?
I expect saw my
Do you know where he's going to be able to
Twitter
stay after this?
feed, but
Is he
every
gonna be
once
able
in a
to go
while
home?
I call it spicy Jen.
I'm just gonna
Normally
not
I
answer
just
that
really
question.
try to
But he'll
maintain
be
a
in the
posture
community. Tell us
of
about this. What's the
no
mood of
matter
your
what
client
people
right now?
say, the
Listen,
ugliness that
that
goes on. I
is
just
something that I will
really
also
try
not
to
comment
just
on,
be
but
very
I will say you
professional and
heard that
not
there
get
was a
involved
condition
in
of
the
bond for him
spats.
to
But
have mental
I
health
tell you
counseling,
this
and we
morning
expect
when
that.
I think
Okay?
it was, and you'll have to follow her if
None.
you
And
follow it all,
I
the
said in
Turner
court,
case
I've not
and
seen the
saga.
police report. I've not seen any other
Gosh,
discovery.
what is
It
that
would be
account? I
irresponsible to
really
comment.
like her.
So
She
I
is
won't.
so funny and so talented with all her
Yeah. So again, not going to come on in that. Thank
videos
you
that
very
she puts
much. But I
together.
do
But
need to
she
get
put
to
together a video
Thank you.
of the blogger, and he's
Oh yeah, yeah.
fussing
Obviously,
because
intense interest there in the
he's
state of
exactly
Michigan
like a
and across the
bully,
country.
the bully that he
In
is,
this case,
but he's
the
basically almost on
lawyer
the verge of
attacked right
crying,
outside the
and
courthouse
because
or
he's worried
courtroom,
he's
not
going
even
to
the
go to
courthouse.
jail. And
He got
obviously,
1 foot
it
out of the
seems to
courtroom,
me to
and
be
boom, the
related
cameras
to
were
his
right there
ex-girlfriend. They had this
because
big breakup,
this
and
is such an
it's
extraordinary story.
literally as the
People
turtle
that follow college
turns
football
that's going on
know
right now in the
Sharon Moore.
Pigpen
They
case,
know him well.
where
He
they
took
are
over for
all
Jim Harbaugh
just
after they won the national championship, and
the
he
two
was
are
going to be
going back
making
and
$13
forth.
million next year,
He
Philip
seems
DeBay.
actually quite
And
believable, and
that is not going to
she
happen.
seems
Michigan
actually
fired him
quite
for
intelligent. I
cause,
don't
meaning,
understand
of
why she
course,
hasn't figured out
he does not get
the
that last
whole
year.
what really
If
happened in
indeed
that
that
case. But I
holds
have
up.
every faith she
Overall
will.
thoughts on what you
But she
heard in the
certainly figured out
proceeding.
the blogger.
What's he facing
And
here?
he was just sick because he feels
Well,
like he's
first of
going to
all,
be
he has
arrested.
almost a
So
$14
I
million
don't know exactly
buyout
what's going
clause
on
in the
behind
contract,
closed doors.
but that's
But I
assuming he's fired
actually
without cause. So let me tell you what I think
put
the issue is going to be here. You have sort of two
on
buckets
my
of legal
Twitter
problems, the
as he was
labor aspect and,
fussing
of
and
course, the
complaining.
criminal
I
side. Let's start
retweeted
with
it, I
criminal.
think. No, I didn't
Criminally, the
retweet. I just did it under
$25,000
her
bail
tweet.
really is, I mean,
I
multi-millionaires
just grabbed
bust
4
there.
clips. Look,
It's
I have a
nothing. He'll be able to
library,
post that in minutes and he'll be out.
probably 100
And I
clips
don't know if he's going back
of
home. I
the
sincerely doubt
blogger
it
and all
because
the
I
horrible
suspect
and
trouble in
despicable
paradise
things he has
given
said
the
about
relationship
the
with
witnesses in
Stanford.
this case,
Now,
about the
having
victim's
said that,
family, about
after
Paul,
listening to the
even
facts
about
as
the mother
presented during
Peggy,
arraignment, I got to
about
tell you, Ted, I
everybody,
fall prey sometimes to media
about
accounts.
me,
I thought he
about
went over there and
other
was making
anybody
threats
who
toward the young
disagrees.
lady. As it turns out,
He
he's
went
threatening to
on
kill
an
himself
absolute
with her butter
tear
knife.
with
So it's one
everybody.
thing if he's engaging in
And
assaultive
anyway,
conduct
I posted 4 of those
to
clips,
the
but one of those clips,
inhabitants
if
of
you
the
have a
home,
chance to
but
take a
no, he
look
was threatening
at
harm to himself.
X,
So
Twitter,
clearly there's a mental health
today,
breakdown,
I
and there
tell
was
you
some
what,
kind of
the way
a
he talked
psychotic
about
break,
Kevin
and he needed to
just
be seen.
really
So the question then becomes,
was
is that a crime? Well, in the
mind-boggling
state
that
of Michigan,
anybody who could
it is
treat
not a crime to
somebody
commit suicide.
that
In fact, it's not even
has
a crime
cancer,
to
that's
attempt
fighting
suicide.
cancer,
And I'm not
and
even
as
sure it is
strong as
considered
Kevin is,
burglary to
talk
go into
about
someone's
somebody
home
who
and
just
threaten
isn't a
suicide.
hypochondriac. I
So
mean,
what do you really have
here's
at
a
most?
guy that
Maybe a
just every
trespass.
day,
And I'm not sure if it's
even when he was
even a
exhausted, in
trespass if
spite of
they
all
let
the
him
weight
in.
he's lost,
So then
he just
the
keeps trucking,
analysis
and he
goes
doesn't
to
want
the
anybody to
civil
feel
arena, the
sorry
labor
for him.
aspect. And
Multiple
depending on
people
what
contact me behind
the policies
the
are
scenes.
of
Oh, you
the
can't
college
hear
and
me?
university, he
Oh,
could be
goodness.
in violation
You really can't
of
hear
their
me?
charter and their agreement that they
Oh
have
my
with
God.
the school not to engage in dating relationships,
Here I
particularly given
am.
the
But
power dynamic between
I'm
supervisors
lounging.
and
But are
lower
you
level
serious? You can't
staffers.
hear
And
me?
that could be a
Oh
per
my
se
gosh, I just went
violation
on a
of their
total,
policy.
uh,
But let's just pretend there is no policy. Well, then you look to state law. And
well,
typically,
disregard.
coworkers are allowed to date.
I didn't know you guys couldn't hear
Supervisors can
me.
date
So,
subordinates. I
court
think where
TV
it starts to
appointments on.
cross a
Okay,
line is if the
sorry.
dating relationship starts to disrupt working operations and business operations. If it starts rising to that level, then certainly the employer can step step in and tell them either, look, if you're going to date, you cannot bring this drama into the workplace, or we're going to have to let you go. And then if it persists, they can certainly let them go. But I think absent some proof of disruption in the workplace itself, it may be premature to be firing him. And I do predict there will be some litigation on the contract.
I mean, there's going to be a behavior clause in a contract of that magnitude for someone in his position. And he allegedly is having this affair with his direct subordinate, his basically assistant. And if she went to them and said, listen, this dude will not leave me alone. I tried to break up with him and he's badgering me. Then you would think that because they came out very forceful. The University of Michigan said, we're done. you and what you did here has no place here in Michigan. So you're right. That's going to play itself out the way it plays itself out. If he wasn't the head coach of the University of Michigan, at the end of the day, would these charges be dropped likely at the end in a few weeks, months? Or how does his celebrity hurt him possibly as we move forward to the way you described this? It sounds like a guy who was desperate. His world had just crumbled, and he had a mental breakdown.
Yeah, I don't think the celebrity hurts him. I actually think it's helping him because as the facts start coming out, he looks kind of human. If you really think about it, it looks as if he was just on the verge of a breakdown, that he wasn't homicidal, he wasn't assaultive in any way, he certainly wasn't making threats to others. If anything, he was a threat of harm to self. And if that's the case, then he becomes a sympathetic figure because the man needs help. That's ultimately what it's about. You don't want anybody to do harm to themselves, and you want them to get the help that they need, be it for medication, behavioral therapy, injections, or maybe he needs to be in a hospital setting where he can be seen for an extended period of time to get him stable and calm. Because just releasing him on $25,000 bond on a promise to appear might not be enough to kind of subdue him and keep him calm. There should have been some evidence presented that he's on appropriate sedatives and medication to treat him to therapeutic levels. Otherwise, he could, in theory, be a danger not so much to the community, but to this young lady again. And we certainly don't want to see that. Because then, if you really think about it, the university could be on the hook. And yes, on threat of harm to himself as well.
Yeah. All right. He'll be back in court January 22nd at 9 a.m. and we'll see how this progresses. But a fall from grace for sure for Sherrone Moore, the former University of Michigan head football coach. We'll get a break. The Walshe jury, they're over an hour. A lot of people on the old Twitter X thought this would be quick because of the defense. But they're at it an hour, and if anything happens in that courtroom, of course, we'll take you there. Plus, we're going to head to Oregon. It's a bond hearing for a man accused of killing his girlfriend in a staged suicide. Interesting case. Stay with us.
Hi, everyone. Okay, is that better? If that is better, I will continue with my discussion regarding the latest on As the Blogger Turns. The ridiculous, well, it's not ridiculous. It is what it is. It literally is like a real life soap opera we're seeing play out with the blogger and his girlfriend. They've had this breakup, and it's so funny. It's in my feed. I just laugh every time I watch it. I cannot imagine the lives that they lead. It's so drama laden. I mean, if you've watched it, the blogger on the ground, throwing a temper tantrum like a 3-year-old. And now he's very worried he's going to get arrested and go to jail during Christmas. So obviously behind the scenes, there's a lot heating up with the situation with the ex-girlfriend. So it's Lydia. I didn't have her name off the top because her name is Lydia Rodarte Quayle, but she goes by the spiciest LRQ. And if you at all are watching as, the turtle turns or, the blogger turns, whatever we call it, you've got to watch her feed and follow her because she's just a hoot. I mean, actually, there's a whole group of ladies that are so talented that are running the fundraising and so forth for the witnesses that were mercilessly shamed, mercilessly attacked by the blogger. But now he's upset because things have turned, and I think he's literally worried he might be picked up. So I'm sure his attorneys are letting him know what's brewing, and he seems to be very worried. And it just brought me back to third grade. We had the guy's name was Sam Waddle. So Sam Waddle, if you're all grown up and for some reason have become a true crimer and hearing this, I'm going to tell on you. So in third grade, he was this chubby kid, and he was bigger than everybody else. And he just relentlessly bullied everybody. And one time we were playing kickball out on the asphalt, and I was running to a base, and I can't remember exactly what he did, pushed me down initially or whatever. And then I got back up in his face, and then he punched me in the eye. So my third grade school photo, I have a black eye. Now, my mom did a pretty decent job covering it. It wasn't one of those big full blown like Mike Tyson black eyes or Rocky, but it was black in a circle. And she did a pretty good job covering it. But it's still obvious. Anyway, just a total bully. And it reminded me of when finally he ended up, because all the sixth graders kind of ganged up on him and put him in his place. He just cried in a puddle. Just absolutely, the bully had been cornered. And that is what I'm literally witnessing. It was funny because somebody said, "Oh my gosh, you went to school with him." And so I want to make that clear. I did not go to school with the blogger, just somebody just like the blogger. So in any event, I'm watching this closely because I'm curious to see if he really be arrested.
Welcome back to Court TV Live. We're following several trials today in cases across the country. In Massachusetts, of course, it's deliberation time. This is when all sides are nervous, waiting to see what a jury will do. And this is the case against Brian Walshe. Over an hour, they've been at it. And we will, of course, head into that Dedham courtroom as soon as we find out a question or a verdict. Anna, his wife, died on New Year's Day in 2023. His defense was, of course, that he didn't know what to do when he found her dead. She died of what's called sudden unexplained death. So rather than get an autopsy and find and explain her death, figure out what happened to this very healthy woman, he decided the best course of action was to dismember her. Go to Home Depot and Lowe's and get saws and everything else and chop her up and get rid of her body. Will the jury buy that? We'll find out. In the meantime, while we wait for anything out of Dedham, Massachusetts, we want to go to Oregon for a bit. It's a bond hearing in a bizarre suicide-turned-homicide case. The defendant here, Gerard Norman. We played some of this a few months back. This is it's a case that at first was a suicide. Prosecutors thought that the woman by the name of Mariah King died by suicide last summer. She had some issues and she had threatened suicide before, but an unspent bullet was found inside of her abdomen. Her boyfriend then was charged with murder. Let's go in now to the courtroom and the defense's opening statement in this bond hearing.
This is a bail hearing. This is not a trial. Time, resources, and other concerns require an abbreviated opening statement from me today. The best interest of court and counsel is for all of us to get on ahead to having these witnesses testify. However, some information about the evidence in this case is worth mentioning now, and that's what I'm going to do for you. This case is a tragic suicide that was turned into a homicide. Our position is that that was done without a valid reason. On July 18, 2024, and I think the court earlier mentioned the date in a PC affidavit as January. That might have been the probable cause for arrest. The incident date that we're talking about is July 18, 2024. Mariah King was at a place called the Going Green Marijuana Dispensary. She was reported there to be intoxicated and paranoid. She had scratch marks on her neck. She told an employee at the store that it was a suicide attempt, which caused those scratches. She said, "I tried to stop myself from breathing." Her mother, Kimberly Lapham, was contacted from the store. The employee knew how to get a hold of her. Miss King and her mother had been recently estranged for over a month. Mariah King discussed with her mother a need for therapy and then left the store on foot. Reportedly, she literally ran away from the place. Kimberly Lapham was worried enough to call in a welfare check, and she did so. Sweet Home Police Department, a guy named Officer Cody McPherson, went to Mariah King's address where she lived with Jared Norman. That's 2241 Nandina Street. Officer McPherson found Jared Norman busy outside. He was working on having a barbecue that day for the people that were at the house. And those people are Jared Norman, Mariah King, Jared Norman's son Barrett, who was 10 years old, Barrett's friend Dylan, who was 12 years old, and Jared Norman's father, David Norman, was also at the residence, although Officer McPherson did not see David Norman because he was inside the house or something like that. Cody McPherson said there was nothing noteworthy about his contact with Jared Norman. Cody McPherson went to the front or main door of the house, and he heard a woman yelling, "Go away," and saying that she was fine. Eventually, Mariah King poked her head out from a shop door, not the main house, but this shop that is attached to it, a workshop of sorts. And she talked to Officer McPherson. She told him, after he asked her, "Are you okay?" She said that she was all right. She said that she was fine, and she asked for him to leave. Officer McPherson noted that she was screaming, that she was possibly angry, and seemed disturbed. He recalled that she probably used profanity during their interchange. He said that Mr. Norman's demeanor was seemingly embarrassed by what was happening, and it seemed like he was feeling down. He did not yell at anyone or use foul language. Mariah King didn't leave that workshop after Officer McPherson drove away. Later that night, Jared Norman discovered that the shop was locked, that she had locked herself inside this building. He eventually got in by finding a key, and he found Mariah King suspended, or partially so, with a rope around her neck. The rope was going through a ceiling eyelet in the shop. I don't know the exact height of the ceiling, but you'll hear about that sooner or later. He immediately called out for his father, who came in. They unwound the rope and they untied it. Mr. Norman started CPR between himself and his father, David. They ended up calling 911. Mr. Norman continued CPR until help arrived from the Sweet Home Fire and Ambulance District.
You need a commercial break. We'll have more from that Oregon courtroom. Plus, Brian Walshe, hour, 13 minutes and counting up in Dedham, Massachusetts. Stay with us. Be right back.
Disappearance of Anna Walshe.
Her husband now charged with her murder. All eyes on this accused killer. The disappearance of Anna Walshe murder trial. Live coverage today on Court TV. Tonight, on closing arguments, Brian Walsh's fate now rests in the hands of 12 jurors. We're live with every development as deliberations get underway. Closing arguments with Vinnie Politan tonight at 8/7 Central, only on Court TV.
Kevin, we were just talking about you, and then that's funny you showed up in chat. But basically, I was talking about a particular account that posted something really funny. To me, it was entertaining anyway, about the blogger who is in fear. This is just from yesterday. He's fearing that he's going to be in jail for Christmas. Remember, he was nabbed up and put in jail for 60 days.
Welcome back to
He
Court
didn't
TV
like
Live.
it.
The Brian Walsh jury
Sorry,
creeping up
they're
to
back.
about 90
Anyway, I
minutes
wanted to tell
into
you what
their
we spoke about,
deliberation on his
Kevin,
fate.
but
While
Court
we're waiting
TV's back.
for anything out of that dead of Massachusetts courthouse, we're watching a case out of Oregon. It's a bizarre suicide turned homicide case. The defendant here is a guy by the name of Gerard Norman. Jared. Authorities initially believed that Mariah King, his girlfriend, died by suicide last summer, but the case took a surprising turn when the medical examiner revealed that an unspent bullet was found inside of King. Let's go back to the courtroom now. The defense, we're having opening statements in this bond hearing, which took place a little while ago. Here is the defense again. We'll pick it up where we left off.
Officer McPherson was actually a person who returned to the residence after this call. He noted that Mr. Norman was distraught, was on his knees, and was crying when dealing with the knowledge that Mariah King was dead after he was informed that that was her condition. A person who is important in this investigation is a person named Kenneth Rosgan. He noted that Mariah King had older cuts on her arm, indicating previous self-harm. Those are the words that he used in his description. Rosgan made other opinions known about this scene, and there are problems with some of his opinions, which will be described during his testimony. Mariah King was not stable mentally. She had struggled with suicidal ideation, had made threats of killing herself on multiple occasions, engaged in self-harm in the past, was diagnosed with things like depression, PTSD, and more. Jasper Lapham is Mariah King's brother. He confirmed her suicidal ideation, among other things, and there's a significant number of other things. Mariah King sent to her brother a picture of herself holding a gun in the very shop where she hung herself. He reported that Mariah King was, quote, going crazy and had mental health issues. He reported that she was an alcoholic who recently relapsed and expressed suicidal statements on the very night she died, as well as on other occasions. There's a documented history of her mental health, and it shows how she has become worse during recent years. There are even text messages to her brother from Mariah King on July 18th, and you'll hear about some of those. Kimberly Lapham is Mariah King's mother. She verified to the police that Mariah King had mental health issues from at least 6 years ago, and that Mariah King had been on and off of medications for her problems. She knew, for instance, that Mariah King had taken a gun from Jared Norman and threatened to kill herself with that gun. She knew and reported to law enforcement that Mariah King had struggled with suicidal ideation. She also talked about suicidal messages and suicidal behavior going back to June 8 of 2024. In fact, Kimberly Lapham confirmed to law enforcement that Mariah King said she would kill herself in that same wood shop where her body was found. For Mr. Norman's part, when he was interviewed, he made zero incriminating statements. He appeared very upset by Mariah King's death. There was an autopsy performed by Sean Hurst, the medical examiner for the state of Oregon. In the end, he said that the cause of death was asphyxia, which is consistent with death by hanging. He said the manner of death was undetermined to this day. There were ligature marks on Mariah King's neck. They were cantilevered over her left shoulder. Those are going to be important. These marks bear some significance in this case. X-rays revealed there was a cartridge casing with a still intact bullet found in Mariah King's lower abdomen. The theory is that that was inserted through her vaginal wall. This is weird. Everyone that would hear that evidence knows that that is strange. Law enforcement was looking for something else, such as how did this get in there? And so what they did was they sent that cartridge to the Idaho State Police Forensic Services Division for analysis. They sent it there because these are experts that use this system called the Recover system. This is a way to detect fingerprints. No prints were detected. The report back from the Idaho State Police says we can do some DNA analysis on this cartridge. No DNA analysis has been conducted. Detective Potter, who investigated this case, seems to think that no prints on this cartridge automatically means that gloves were used to insert it. Mr. Norman was interviewed in July and then again in August of 2024 and again in January of 2025. And it wasn't until January of 2025 that he was confronted about this bullet, a bullet that is still in the cartridge. And he was mystified by that and told the police, like she ate it. He did not understand how that cartridge came to be inside of her body. Furthermore, he admitted that it's the kind of cartridge that goes to his rifle. He said something like that came from my rifle, or that goes with my rifle. And he also said this was a bizarre and weird occurrence that he could not understand. Detective Potter told Mr. Norman that the bullet was inserted after death. The medical examiner, Sean Hurst, disagrees with that and says this is a peri-mortem injury. It could have been inserted before or after death. Mr. Norman didn't make any incriminating statements ever and was open even about some of the issues that existed in his relationship with Mariah King. That's a summary of some of the things, and again, it's very different from a trial, but that's a summary of some of the things that you will hear testimony about today.
All right, defense attorney laying the groundwork there for the judge in this case. Again, this was a bond hearing of a bizarre. The woman, initially it's a suicide. She's found hanging. The boyfriend's father is there fairly quickly as well when they try to render aid. And then they flip it all up and say this is a murder after they find this unspent cartridge, rifle cartridge, in her abdomen, which was, they believe, got there through the vaginal wall. Philip DeBay is with us. I don't know how that says murder. What's your take on this? It's weird.
Believe it or not, Ted, I have seen this actually many years ago when I worked in the juvenile division in the delinquency courts. We had a young client who had a similar problem. It's a form of self-harm, and it's not, I'm not going to say common. In fact, it's rare. But basically what it is, it's a type of vaginal foreign body insertion. And sometimes they call it DFBI, literally deliberate foreign body insertion. We see it in suicidal people, even in the juvenile community. We see it particularly in people who are emotionally unstable, who have personality disorders. And I think it's sort of, making some headway in the forensic world now where they've given it an official name. It's called polyembolocoalamania. And basically what it is, it's a psychiatric, psychosocial disorder that they see in psychosis and in suicidal people. And they've also found it in gynecological literature. And it's a pretty complex patient cohort, but we do see it. It's almost like a form of self-mutilation, and it can be done, you know, pre-mortem and certainly peri-mortem, if you will, but it does not, by any stretch of the imagination, prove a murder.
Yeah, and it sounds as though this case, if and when it goes to trial, will be a battle of experts, and it sounds like some of the literature you have read needs to be brought into this case. But because it's so uncommon, it'll take that, right? It'll take some expert testimony.
Yes, it will. And that is an absolute defense because they're hanging their hat on that some third person deliberately and intentionally and maybe sadistically inserted that casing into the vaginal cavity I mean, that's the bottom line. But the truth is, it is a form of self-harm. Again, it goes to that DFBI, the deliberate foreign body insertion. And again, more scientifically, they call it polyembolocholomania. And it's actually in the literature, and it's really starting to take off, frankly, though, in the gynecological world, where more and more gynecologists are seeing evidence of this, and they're all scratching their heads because they're not trained in psychiatrics and they're not trained in forensics. They're there really to treat the medical aspect.
Well, Philip DeBay, that's why we have you. You have all the information we're after, and we appreciate you. Enjoy your weekend. We need a break. More from Oregon. And Brian Walshe, what is the jury thinking about? Good golly.
Times the impact to help more kids.
Thank you for giving.
And welcome back to Court TV Live. I'm Kelly Craft, sitting in today for Michael Ayala. Thank you so much for being with us on this Friday, and it is a busy one here at Court TV. We are in Ohio. Day 3 of testimony continues for Paul Hicks. He is the man accused of drowning his estranged wife. This was in a car nearly 25 years ago. Also, we are in Florida. The penalty phase remains underway for Jason Benengus, who pled guilty to the October 2021 murder of an officer. Closing arguments begin there on Monday. In Michigan, former University of Michigan head coach Sharon Moore, he appeared in court via Zoom. He was charged with several crimes, including home invasion and stalking a person that he was dating. And finally, in Massachusetts, a jury is deliberating the fate of Brian Walshe. He is accused of killing and dismembering his wife, but he says that she died a sudden death. And that is where we begin this hour. Why don't we go ahead and bring in trial attorney Tamika Grabowski to discuss what we've been seeing so far there in Massachusetts. Not much so far, because we have the jury deliberation clock up. We're at an hour and 33 minutes, so not too long. Talk to us about what you think is taking place in that deliberations room right now, Tamika.
I'll be honest with you. I'm a little surprised. I thought that they would be in and out. The number of issues that were raised with respect to what happened after she died, and the fact that he disposed of the body and did all the searches, things like that. It's actually surprising to me that it's taking this long. However, when there is going to be a guilty, I do think that jurors are conscientious enough to make sure that they go through everything to make sure that they are comfortable with a decision that is going to affect someone's life, and in this particular situation for a very long time.
Tamika, do you think any of them are maybe considering some of the arguments, and they're considering the arguments by the defense, that's what they're supposed to do, but in regard to this idea that he panicked, he didn't know what to do, and so then he chose to do what we've all heard about, chopping up his wife and getting rid of the body. Plausible at all? I mean, do you think it's possible they're thinking this?
I think that goes to what I'm saying in terms of making sure they go through every single thing. When they are back there deliberating, they're going to absolutely look at the defense and what he's saying, and then look at that and see, okay, we have this evidence over here, this evidence over here. And in terms of the prosecution, because of course the defense doesn't have to prove anything, has the prosecution laid out their case, and then look at that versus, the plausibility of, I just kind of panicked and I decided to